Here the grievance of the petition has been
Make use of
forwarded.
the mic.
That's it. The grievance of the petition has been forwarded to the OP2. Let's me directed the OP number 2 to dispose of the grievance of the petition within stipulated time. That is why the annex.
They have not done that.
No, they have not.
You are
What is the prayer?
directed to appear before the collector on 6/8 and he has appeared. Only final order to
Correct.
annexure 5, your lordship.
For reversal of grievance of the petitioner. What is this prayer? I do not understand. What is this prayer, Mr. Lenka? What he want? What you want, brother?
That's why here.
Repeat your prayer. What your client wants at the hands of this court?
Here, in fact, there is some massive corruption with regard to distribution of corruption. With regard
Corruption.
With regard to distribution of school uniforms.
You want information relating to that?
No. I am the my children were prosecuting that particular institution. What the corruption?
Who are you?
I am the parents of the children. Those who are prosecuting study. And they said
You came to know that
He is the complainant. He is the complainant.
he is the complainant.
And I also brought.
And he submitted representation before the Honorable Chief Minister.
That is
And that has been forwarded to the collector for
The
inquiry.
collector has to take that.
Already, as per Annexure 5, he appeared before the collector with his documents. So, collector to pass an order. For
Yes.
that, he has come.
Right down. The short grievance of the petitioner is as to long pendency of his complaint, which he had made to the Chief Minister of the state, who in turn had sent it to the jurisdictional collector of the district for consideration. First off, counsel for the petitioner submits that on 6/8/2025, his client had appeared before the collector and participated in the proceedings. And since then, more than 5 months are over and nothing has been done in the matter. Therefore, counsel submits, intervention of the Great Court is warranted. Next paragraph. Learned AGA, Mr. Lenka, appearing for the OPs, very fairly submits that he would instruct OP number 2 to look into the grievance of the petitioner in a time-bound way if all contentions are kept open and a reasonable period is prescribed. First of all, with this proposal, counsel for the petitioner is agreeable. Next paragraph. 6 weeks. Open to solicit, web copy to be acted upon. All contentions kept open. Item 2.
I am from the VC, my lord. I prefer time, my lord. I prefer time, my lord.
What is this? You require the take of members separate from
The read appeal is pending before the.
You take decision on the leave application. You cannot keep the applications pending.
It's not leave application. They're claiming the provisions under the rule that is under challenge before the Honorable Division Bench in a read appeal, a Hemanta Chotrai case. In similar cases, your lordship disposing of the read application and subject to outcome of that.
Writ appeal.
Yes.
Writ appeal.
That is normal.
We'll print the same order.
Same.
Petition prayer reads. The prayer in one of the petitions reads as under. Only first one. Counsel for the petitioner submits that all these writ petitions have a common fact matrix and therefore similar law would govern them. First one. He also brings to the notice of the court that the learned single judge of this court has already accorded relief to petitioners of the kind, and therefore the same should be extended to them as well.
Yes.
First one. Next paragraph. Learned counsel Mr. Lenka tells the court that in identical matters, this court has although granted reprieve in terms of the judgment of the learned single judge in WP number so and so. Give that WP number.
That is mentioned in paragraph 5, page 5.
Page 5. Look into that. Full name, date, judge, all these things. So and so. Come on. The matter is put in challenge in writ appeal number.
That I do.
Writ appeal number you have to give. Okay. Which is that writ appeal number?
160,000.
This is your
17,067.
the
820.
right down in. Good. Yeah. He is pending, and therefore the petitioners should await the final outcome of the said writ appeal. First off. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant relief to the petitioner as has been granted by the coordinator in the coordinate case, subject to outcome of the writ appeal, in as much as it is stated at the bar that there is no interim order granted by the division bench. You said other day there is no interim order. Mr. Lenka,
Yes, sir.
you said in the writ appeal there is no interim order other day. There is no interim order. Ordered accordingly, and these writ petitions are disposed of. But that is. Okay. So number 3.
My lord, same matter.
Same shall be subject to outcome of the writ appeals. Okay.
My lord, same matter. Item number 3.
Item number
3, sir.
Number 3 is the same matter.
3 is also same.
Same.
Okay.
Ma'am,
Let's put one common on that.
my lord, item number 6 and 12 is the same matter.
6 and 12 also.
Yes.
Go to 6. 6. Go to 3 first. To the prayer. Go to 6. Go to
12.
12.
Yes.
Then.
Yes.
Yeah. Item 4.
May I please, Your Lordship?
Yes.
The petitioner is before this honorable court challenging non-payment of the balance earned leave of 83 days. Out of 300 days of balance earned leave, he has been paid only 217 days. And he has approached this honorable court earlier in WPC number 37,000.
Alex. So where directed consideration of representation. Now what happened?
Then they did not consider the representation within stipulated period of times of 8 weeks. Then the petitioner filed contempt bearing number 2783 of 2022,
Then
which
what?
was disposed of on 20th.
Already. The contempt it is rejected.
Contempt within the order was passed by this honorable court to dispose of the same within 1 month. Then they did not comply. Then they filed the second contempt. Second contempt, they have given opportunity of hearing and they disposed of. And which is at annexure 4, Your Lordship.
Rejected. You take notice.
Yes, sir.
Lenka, you request it also notice for the numbers, copies, all of this. Yes. Item 5. Go to the prayer. Kind of prayer. He wants dismissal of the teacher.
Yes.
Well, on what ground?
Fake certificate.
Fake certificate is given.
Yes. He allegation is. And he has filed a representation at annexure 4.
You just consider that.
Not legible, he is not sure.
Then ask for legible copy, he will give one.
Yes, sir. Annexure 4, representation.
Prayer reads as that. It is preceded by a representation dated.
Representation dated.
In Orissa. 10/2/2025. 10/3/2025.
3/5/25.
Huh?
3/5/25.
No, 10/5 left, it is 10. No?
Somebody has some signature.
Yeah, 10/5/2025. Before knocking at the doors of writ court, wherein similar request has been made. First, where a representation of the kind is made to the jurisdictional authority comma, he has to take a call thereon within a reasonable time and in accordance with law. Is the mandate of Article 350 of the Constitution of India, as has been extensively interpreted by various high courts in the country. First up. Next paragraph. In AGA, Mr. Dalka, having resisted the petition for some time, now agrees to instruct OP number 4. OP number 4 to look into the grievance of the petitioner as has been aired in the subject representation in accordance with law, if all contentions are kept open and a reasonable time in prescribed. First off, this is fair and reasonable. Next one, the above circumstances, 6 weeks, 8 weeks. Solicit. Yes.
Item 6 has been disposed of. Item 7.
May I please your lordship? My lord, petitioner challenges annexure 4, my lord, page number 14, my lord.
Which certificate do you want?
My lord, what has happened in this case, my lord? The petitioner appeared +2 examination year in the year 2014, my lord. And they have issued provisional mark sheet. And on the basis of that mark sheet, my lord, petitioner acquired higher qualification. When the petitioner approached, my lord, of her original certificate, they did not issue. So the petitioner filed a writ petition before this honorable court. This honorable court directed to consider, my lord.
Okay.
After that, my lord, they have issued annexure 4, my lord. And in this letter, they have stated that, my lord, this is a human error that has crept in at the time of issuance of mark sheet, my lord.
What has happened? What is that error?
My lord, they have issued provisional mark sheet, my lord, in favor of me. And by virtue of that mark sheet, my lord, I have acquired a higher qualification, my lord. They have done mistake, my lord.
Indicate notice to go there. Again, the
Issue.
rejection order.
Emergent notice.
And OP1.
And the AG is requested.
No,
some notice.
1 and
1 and 2. No, 1.
no 1 and 2 notice to be sent. They are having one panel.
1 and 2.
Yes. Council of Higher Security.
You appear for 3.
3.
Mr. Lenka, learned AGA on request accepts notice for 3, emergent notice 2, 1 and 2. Since a short point is involved, call this matter immediately after service. Okay.
Item 8.
Good.
My
Same matter, my
lord,
lord.
myself, Advocate Sandarani Pani from BC Barampur, my lord. And my claim is that the salary of petitioner from 14/6/2017 to 6/12/2021, my lord. And the fact of the case is that, my lord, initially the petitioner challenges the transfer order before the tribunal, my lord.
Please.
And the tribunal passed order of stay order, passed the stay order, my lord, as per annexure 1. In spite of that, they
In this case, my application is pending before
NOC in favor of petitioner's sister to impart.
for opening of College of Physical Education, my lord.
What is the normative basis for claim? Under which law? Where is your statute book? Have you ever seen any peasant going to the land without the
No, my lord.
call of 3 weeks to enable counsel for the petitioners to bring the law books?
My-
Okay.
Item 10.
May I please, your lordship? May I please, your lordship, on behalf of Mr. Devenath Mishra, my lord. My lord, here the petitioner claim for the area
In respect of what is, how arrears, in what connection?
my lord, annexure 1 para page 14 para 3, my lord. They have rejected my claim, my lord. And thereafter, similar situated person approached this honorable court in the application as the ratio is not
Tarsem Singh.
my lord.
The representation is pending.
Let them consider the representation prayer reads as that. Petition is preceded by giving a representation dated 2/9/2024, a copy whereof is at annexure 3, full stop. The last paragraph of the said representation reflects the relief which the petitioner wants. And the same reads as under. Go to page number 19, last paragraph. Next paragraph. Learned counsel AGA Mr. Lenka agrees that The representation of the kind should meet its fate at the hands of the jurisdictional authority within the reasonable time. First off, he assures the court that he would ensure the disposal of the representation in accordance with law if all contentions are kept open and a reasonable timeline is prescribed by the court. First off, this is appreciable. Next paragraph, 8 weeks. Open to solicit, no cost. You have copied. Next.
Item 11.
Same to 10, my lord. Same as 10, my lord.
Yes, same.
Item 12 has been disposed of. Item 13.
13.
Item
Sharat
13.
Chandra. Sharat Chandra is like item number 2, 3.
Yes, ma'am.
Huh?
Yes, ma'am.
Fine.
That is pending, the writ appeal is pending, awaiting the final decision.
Same order as in serial number 2. Serial number 2. Same order. Yeah.
Item 14.
May please, Your Lordship. My lord, here the order of rejection for notional promotion is under challenge, my lord. Your Lordship may kindly come to page 89, annex 8.
And very 8.
My lord, page 8.
That's how it has been rejected.
My lords.
Results of pedestrian signed to all signs and signs and additional promotion to the rank of the involved in the production and the even fitting submit for the rank of here. Where is the reading?
The petitioner retired since 2019, Milan.
Right. But he is not a Mughal. Your joint secretary of the government is not a Mughal emperor. He does not give farman to the people. He is a servant of the people. Simple servant.
No reason, sir.
Where is the reason? Any other order is given to you?
No, this is the only order. This is the only rejection order.
I'll set aside this order with the direction to reconsider. Petitioner's request for notional promotion having been rejected by the order dated 17/1/2025, a copy whereof avails at annexure 8, he is green before the writ court. First off, the impugned order being as cryptic as can be, is reproduced below. First, next paragraph. Learned counsel for the petitioner submits and this court agrees that the cryptic orders cannot be passed by the state and its functionaries, giving of reasons being essential requirement of principles of natural justice. First off, an order is non-speaking is a ground for its invalidation, said the apex court in more than a dozen cases. First, next paragraph. In the above circumstances, petition having been favored, a writ of certiorari issues quashing the impugned order, and matter is remitted to the portals of Joint Secretary to Government for consideration afresh in accordance with law. First off, it hardly needs to be stated that the order to be passed within 8 weeks from this day shall be a speaking order. And a copy of that should be marked to the petitioner by speed post, registered post, as the case may be. Okay. All contentions kept over. Next.
So next sub item is same. Same non-speaking order, page 91.
I'll quote that also. Separate orders. Okay.
Item 15.
What kind of orders, sir? Why they should not be
Only they have
sent
said
to
that it's
for a few days?
regretted.
Regretted. What we should do for let him sing a requiem.
And that should be a reason order. Because of this.
Next.
May I please, Your Lords? Here, my lord, my grievance is the petitioner's pay has been reduced by deducting one annual increment and recovery has been directed.
Any hearing, show cause notice?
No
etc.?
so cause notice. I have brought a judgment of the Honorable Apex
No,
Court.
not necessary for that. I am asking.
No so cause notice, nothing.
Where have you stated in your grounds?
My lord, Your Lordship may kindly see.
No opportunity of
Para 10.
Read.
That it is pertinent to mention here that the District Education Officer Khordha, while passing the impugned order dated 24/4/2025,
has not issued notice to the petitioners and without complying the principles of natural justice.
Take notice, Mr. Because it is in April. It is.
Yes, April. Till date, no recovery has been made.
And there are 9 petitioners.
Yes, same school. So
Same school.
the proposed
Can't we, instead of staying, can't we set aside this so that you, after giving opportunity,
yes.
take the decision?
Yes.
Because some of them have retired and some of them
Only 2 persons have retired.
We will assume that everybody has retired.
Only 2
Can you
persons.
do it without notice to them? Or you want to
let
take
that be
notice?
reconsidered.
Reconsider.
Yes, well, let me set aside that all.
The grievance of the petitioners essentially is against recovery order that has occurred because of withdrawal of 1 annual increment.
Yes.
First off, learned counsel for the petitioner submits that increment is a monetary value and that would constitute property under Article 300 capital A of the Constitution of India. And therefore, without due process, that exercise could not have been undertaken. First off, next paragraph. Learned AGA Mr. Mohanty, on request accepting notice for the OPs, resisted the petition for some time, contending that even if notice is given, no useful purpose would be served, and therefore the ground of violation of principles of natural justice would not come to the aid of the petitioner in the light of decision of apex court. In Jagmohan versus
Yes.
S.L. Kapoor versus Jagmohan, or Jagmohan versus S.L. Kapoor.
And another decision, Your Honor.
First, no, that is his decision.
Yes.
Next one, having heard the learned counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence as under, and for the reason that an order without compliance with the principles of natural justice is unsustainable. First off, it hardly needs to be reiterated that even the God is said to have given an opportunity of hearing to Adam and Eve for consuming the proscribed apple in the Eden garden. Come on, says the Bible. First off, that being the position, man cannot arrogate to himself the wisdom which even God did not claim. First off, next paragraph. In the above circumstances, the writ petition succeed. A writ of certiorari issues quashing the impugned order. One order. Impugned order. First off, matter is remitted to the portals of
District Education Officer, OP number 3.
OP number 3, DEO, for consideration of fresh in accordance with law and after affording an opportunity of hearing to all the stakeholders, including the petitioners hearing. First off, all contentions kept open, no cause. Next.
Item 16 has been disposed of. Item 17.
This case, the petitioner has very small pair. Petitioner has filed this case for direction to the opposite pet number 2, 3, and 4. Chairman Housing Board, the State Housing Board, Secretary State Housing Board, and Assistant Administration Officer Urban versus State Housing Board to record the allotted property in the name of the petitioner.
They allotted property.
Yes, my lord.
Why are you here? If you have been given the property.
No, my lord. That property, originally that property belongs to my mother. After death of my mother, the father and the elders, the present petitioner, they have applied for the change of
name.
Allotment. The younger brother and younger sister already relinquished her share.
Have you implemented you are saying on your own that they have relinquished the interest?
Yes.
But what is the guarantee?
I have annexed that under Annex 2, my lord. The deed of relinquishment is there.
Is it registered?
Yes, my lord.
Only change of khata.
Change of
allotment.
Ownership, my lord. Ownership from the name of mother.
Not change of ownership. Change of ownership happens by operation of law by succession.
Okay.
It has happened now. Only that should be reflected in the records.
Yes, well.
That's your case.
Earlier occasion,
take notice. Take notice.
Previously, the cost title ballot in the entire ballot body of the petition, but opposite part of 4 and 5 are there. But in the cost title, no opposite part of 5 and 6 is there.
Anyway, just look into it and you can use it as a ground for resisting the petition. Issue emergent notice. Learned AGA Mr. Sen is requested to accept notice for one emergent notice to the rest. First time, since a short point is involved, call this matter in the second week of January 2026. Okay.
Item
The
18.
pendency of the petition will not come in the way of granting the relief which the petitioner has sought for in the writ petition.
Item 18.
In this writ application, the petitioner is praying for a direction to the opposite party for a grant of family pension in her favor, madam. Her husband was working as a assistant teacher of
Family pension to be paid.
my lord.
Is she widow?
My lord.
Widow is entitled to family pension.
Not she.
Any representation application is made.
No, my lord, I may be permitted to file a fresh reprint.
Yes, you have to file that one, na? Petition prayer reads as that.
But death certificate is also not there. Death certificate and legal heirs.
No, everything he has to give that one.
My lord, with all documents.
Counsel for the petitioner argues that her client's husband having died, now the family pension needs to be sanctioned and released, and that the same has not been done. First off. Therefore, he seeks interference of this court. First off. Next case. Learned ASC on request appearing for the OPs opposes the petition contending that no writ of mandamus lies unless a demand is raised and rejected. Normally. First off, he quotes B.L. Hansariya's writ jurisdiction under the Constitution in support of this version. First off, there is force in this submission. Next one, in the above circumstances, writ petition is disposed of, reserving liberty to the petitioner to make an appropriate application in the prescribed form, supported by vouching material. First off, if such an application is made to the proper authority, the same shall be disposed of within an outer limit of 8 weeks. First of all, contentions in that connection are kept open. Okay. Next.
Item 19.
Yes, this petition is a matrix city teachers with 10 graduate qualification, my lord.
What we have done in similar matter?
My pardon?
Notice we have issued, brother. Same.
He is claiming, my lord, MSc benefits, my lord.
Correct. We have already representation is made.
No representation is made, but not unless this writ petition, my lord.
Do you have representation with you?
No, my lord, that is not with me.
When you make representation, then they will consider
your
petition reads as done. First off, learned counsel for the petitioner submits that a direction be issued for the relief which the client has claimed in terms of the petition prayer. First off.
So, collector, opposite panel 2.
Opposite of 2 minutes.
By the OP number. However, next paragraph. When asked as to whether his client has made any representation seeking the benefit in terms of the petition prayer, counsel for the petitioner in all fairness admits that there is no such thing. First off. Learned ASC Mr. Singh tells that in the absence of demand and rejection, writ court should not interfere. First off, I agree. Next paragraph. In the above circumstance, petition is disposed of, reserving liberty, same to make an appropriate application in the prescribed form, producing vouching material in support of that within 4 weeks. First off. If the same is made, OP number 2, OP number 2 shall take the decision on that and inform the decision taken to the petitioner within an outer limit of 3 months. All contentions kept open. Next.
Pardon, my lord. My lord, claim of the petitioner for claiming MSCP benefits.
Whatever you want to claim, that you should claim in a representation. Then you come to the writ court.
Original copy.
Item 20.
Matter related to headmaster scales. Similar matter already issued notice.
Issue emergent notice. ASC is requested to accept notice for the OPs, all along with WP number.
Item 21.
Sub item also same.
In this case, petition seeking lecture group A scale and state scale.
Be louder. Be louder.
Petition seeks for lecture group A scale and state scale. In the light of Loknath Behra case,
Loknath Behra, have you got the judgment? Yes, give that. Have you changed the factors? Disposed of. Same, you have to change that one. One particular line was missing that. Let's look into that. Yes, next.
My lord.
Item 22.
The IACP scale of a playing by the petitioner, my lord. Similar matter, your lordship has passed the order
2003 OLR.
Yes, madam.
Same order. Next.
Item 23.
Application fails into incident.
22, there are two items.
Same item, same order.
Yes,
Connected state.
Yes,
collected matter similar.
yes.
Item 23.
After relating to regulation, in identical case, your lordship has some brought.
But interim order is granted. Learned counsel for the petitioner submits that the subject matter of this petition is substantially similar to the WPC number 33278 of 2025, wherein this between Videshi Behera versus Orissa University of Agriculture and Technology, wherein this court has granted reprieve. And therefore, counsel submits these claims also be extended the same, they being similarly circumstanced. First, there is force in this submission. In view of the above, the interim order as has been granted, the order dated 10/10/2025, as has been granted in WPC number 28494 of 2025, is extended to the petitioners mutatis. Call this matter along with WP number. Next.
Item 24.
Issue notice. Fine.
Covered by Ashok Ma'am. It's covered by Ashok Ma'am.
I have given the copy with Mr. Behera to Behera. The only order to be date to be changed. Name and date. This this sentence is incomplete, na? That you have to complete. Next.
Item 25.
Yes, petitioners to owners of their Sisiban land miller, they are using
Not to obstruct the petitioner to use the embankment of channel plot number so and so. What is your right?
No, I am the pathway. I am using the government land.
You are using the government land. Which
As
law
pathway.
gives you that right?
As pathway, my lord.
Pathway. Which is the law which gives you that right?
The government land am I using, my lord?
Petitioner to come with more preparation. Counsel for the petitioner to come with more preparation to answer relevant questions of the court. First of call in the first week of second week of December 25. Next.
Item 26.
Sole grievance of the petitioner is that disposal of appeal is pending under Annexure 7 before the opposite part number 1.
Appeal of which year? 2020.
Sir.
OP number 1 is who? Principal Secretary.
Secretary, sir.
Appeal under
24B.
24B of Education Act.
No, sorry. 24 of service OCCC rule.
24B of
24 is 24 of OCCC
Rule 24.
Sir.
Is that true? How it reads? CCA rules, sir. CCA rules.
OCCC rule.
Perfect. Right now. The grievance of the petitioner is against the long pendency of his departmental appeal against an order of disciplinary inquiry.
Sir.
First up. This appeal is said to have been filed under Rule 24. 24 is period of limitation. The 22, that's the order. Sections 22 and 23, rules 22 and 23 of Orissa CCA, Orissa Civil Services CCA Rules 1962. First, counsel for the petitioner argues that an appeal of the kind cannot be kept eternally pending to the detriment of his client, right to speedy justice being a facet of Article 21 of the Constitution of India in the light of a plethora of decisions of the apex court. First stop. Learned AGA, on request appearing for the OPs, very fairly agrees that he would instruct OP number 1 to hear and dispose of the subject appeal if all contentions are kept open and a reasonable period is granted for doing it. With this proposal, counsel for the petitioner is agreeable. Next paragraph. 8 weeks.
Item 27. 27.
Relating to regulation of service for initial engagement, similar matter your lordship is noticed.
Issue emergent notice. AG is requested to accept notice for 1 to 4. 4. Only 4. Emergent notice to who appears for the next?
Only 4.
Only 4. Emergent notice to.
No, sir.
No, 3 and 4. 3 and 4. Emergent notice to 1 and 2.
1 and 2, Mr. S.C. Ratho.
In addition to taking usual steps, it is open to the petitioner to serve copy of the petition along with all the documents on the learned panel counsel who usually represents 1 and 2. OPs 1 and 2. Next.
Item 28.
Second round litigation. Challenging the order to 11/9/25.
It is that 5/11/24.
Control of account under Annex 6, my lord.
What does it say?
After retirement, the opposite part number 4, control of account, deducting the amount of 1,78,900.
What is your designation? Whether Rafiq Masi is applicable? What is your designation?
Typist. Junior.
Typist.
Junior.
Typist is which group?
My lord, sir.
Class 3. Class 3.
Class 3. Rafiq Masi is applicable.
My lord, it is not recovery. It
Take
is,
notice.
this is, yes, my lord.
Where I requested to accept notice for OPs. But the matter lies in a narrow compass and therefore call the same in second week of January 2026. Yes.
Item 29.
Group 3 is Rafiq Masi. Rafiq Masi, yes. Yes.
Item 29.
First appeal to be disposed of. Short grievance of the petitioner is against the long pendency of his cash appeal number 13 of 2021 pending on the file of
Collector.
the file of OP number OP and the solo OP file of solo. First up. An appeal of the kind cannot be kept pending eternally by the officials of the government to the detriment of the citizen. First off, a citizen is entitled to know the fate of his appeal, this side or that side, within a reasonable time. First off. Next paragraph. In the above circumstances, OP is directed to hear and dispose of the appeal in question within an outer limit of 8 weeks from this day.
3 months.
3 months. 3 months. Within the outer limit of 3 months. First off, delay shall be viewed very seriously and at the next level of the litigation, heavy costs payable personally by the OP may be ordered. Okay. Next.
Item 30.
May I please your lordship?
Why 5 years, 3 years for pending appeals? What the officers are doing? Are you drawing the officers from the Indian administrative service or from kindergarten? Why for first things they should waste a constitutional court's time?
Yes.
There are heavy matters. Yes.
Your lordship.
I will impose heavy cost in some matter. I am just waiting for that. I will impose a 5 lakh rupees cost. Then the people will know. Yes.
Lordship, I'm appearing on behalf of Dr. Mishra. I'm seeking for a Passover.
Passover? Why Passover, daughter? I will help you. Come on, take out, read the papers.
Lordship, there is a matter wherein the petitioner is challenging the withdrawal of grant in aid under Annexure 6, your lordship.
Is it? They could not have withdrawn.
No.
Why they have withdrawn?
Your lordship, the opposite party alleging that the petitioner was underqualified during his appointment. Your lordship, he was not
What was his qualification?
intermediate, your lordship.
What is the required qualification?
It was intermediate, your lordship, but
Where is that status shown?
your lordship may come to Annexure 10.
Age?
61, Your Lordship.
My lord's allegations that he was not appointed.
He was not
there is no
appointed at all.
records. And by he had not passed IA by the time he was appointed. There are a lot of allegations.
Your
You
Lordship,
take
Your
notice.
Lordship,
Take notice. Heard learned counsel, Miss, what's your sweet name?
Eliza Panda, Your Lordship.
So, who has argued very well and made out a case for issuance of notice. First up, issue notice. Learned AG requested to accept notice for 1 to 3.
3, my lord, so notice will go.
Principal cum secretary. You are not there. All 1 and 2. Emergent notice to the
Your Lordship, there's an IA for.
No interim order in matters like this. It's a one. The application for interim relief will be considered after service of process. But next.
Item 31.
May I please, madam?
Yes.
Well, petitioner was appointed as an assistant teacher on, my lord, 24th of November 2001, my lord. While she was
Approval of appointment.
no, my lord. What has happened, my lord? While she was continuing, she was prevented on 16/4/2007. She filed an appeal before the director. The director allowed him to appeal on 26/9/2015.
Your prayer is for approval.
The prayer is, my lord, though DEO has
Kindly read that.
no, sorry, though DEO has already passed an order, my lord.
Passed an order.
Annex of 12/70.
But that you are not put in challenge.
No, I am not passed order in my favor, but in spite of that, he is sitting over the matter, not taking decision. Page 71.
Mr. G. The petition in terms of that.
My lord.
Petition prayer reads as that. Counsel for the petitioner draws attention of the court to the order dated 2/8.
My lord.
2/8/2024, a copy whereof awaits at Annex 12, made by the district education officer. One second. The last paragraph of the order reads as under.
Last two paragraphs.
Last 2 paragraphs of the order read as under. First off, next paragraph. Learned counsel for the petitioner submits that despite this order by the higher up, who has to take the decision?
He himself is to take a decision.
Only despite this order, the same has not been implemented, and as a consequence thereof, the petitioner is put to a great prejudice. First off. Next paragraph. Learned AGA Mr. G on request accepting notice for the OPs very fairly submits that he will confer with his official clients and direct them to take appropriate action in terms of the order in question in accordance with law if a reasonable time is granted. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. In the above circumstances, 4 weeks.
Item 32.
Item 32, it's a contempt matter, my lord. Here, my lord.
What was the order?
Revision of pension. The petitioner has paid for revision of pension. My lord, in this, I must have recommended. I'm placing.
He's saying something. It may be in your favor also.
My lord, no, the rate appeal is pending now. Not in this.
Any interim order is granted?
That I do not know. I have
Otherwise, no interim.
my lord. Lordship,
If there is an interim order, you are bound to comply with
comply with the order. My lord, Lordship, WA number 1042 of 2024 is pending. My lord.
No, pendency is no ground. It said in EM Nambudri Park.
Yes.
Pendency of appeal is no ground.
Unless interim order,
Yes.
interim order is passed therein.
Yes.
I'm conscious of that, my lord. My lordship may keep it. I will file an affidavit. Against this rate application, he has not filed in the rate appeal, my lord.
That's what he
Then
is another writ appeal.
in another case, not connected to this case, my lord.
No writ appeal is filed.
No, rate appeal file is filed in.
G will issue police notice to the approved.
No. He is not sure.
Necessary.
He is not sure. The order was passed by the BO Vastarangad. It speaks like this. The Honorable High Court of Orissa, while disposing of the writ petition bearing number 33024 of 24, this is the present writ application, disposed of on 29/7/25 filed by Parthing Chandra Biswal versus State of Odisha and others. and operative portion of the order is quoted and here under. He has quoted it here and has passed an order.
What order? He is pending. Is it an order?
No. Here, that BO has passed an order. But
I'll direct arrest and detention.
my lord, because of the
No.
because of the fact,
Unless you bring the pendency is no ground,
my lord,
except in three circumstances which the case does not fit into.
my lord,
Pendency is no ground.
I'll file a affidavit.
G is requested to issue emergent notice. G is requested to accept notice for all their private parties. You appear for them.
No.
They will issue emergent notice to the
My lord, no. Their BO is there. Government is
Mr. G, kindly see the cost item.
No. Cost
Please
item.
nominate.
Yes,
We'll issue notice to them.
my lord.
Issue police notice to OPs 1, 2, and 3. Emergent notice to fall. No, all.
All four.
All. Yes.
Item 33.
Let's 22nd to August to appear. I will issue notice and appearance also. Issue notice, the police notice to OPs. And they are mandated to appear before the court in person on, tell some date.
If not compliant.
That's what. On so and so, whenever date, whichever date.
And the
On 9,
a little more, my lord, because
16/12/2025 to offer explanation. Next paragraph. However, personal presence would not be required if in the meanwhile the writ in question is complied with and the compliance report is filed.
Item 33.
Lordship, 22nd August 25 order is flouted. Lordship, kindly come to page 15. My lord's order. In the above circumstances, this writ petition
Mandamus follows to OPs to select and appoint the petitioner to the post in question in any vacancies for compliance to the Registrar General of Court within an outer limit of 8 weeks.
8 weeks.
Not complied with.
Order was on 22nd 8
I'm asking
2020.
you.
Not complied.
Answer the question of before.
Lordship.
Issue. Who should comply?
Collector and BO. BO.
Issue police notice to OP numbers 1 and 2 to appear before the court personally on 16/12 for offering explanation as to why the writ in question is not complied with. First one, next paragraph. However, not required science. All right.
lordship fixed to that.
16/12. On one particular day, I will have only contempt matters.
Yes.
So that all officers will be here instead of in their offices. Yes.
Item 34.
My lord, my lord, senior advocate, Mr. Mahapatra is on his legs, my lord.
On his feet.
On his
Feet. Okay. Pass over.
Obliged.
Item 35.
It's a contempt matter. Non-compliance of order dated 5/8/2025.
What is the order? Positive order?
No, my lord. Your lordship directed for consideration.
Consideration has not happened.
Not happened.
Who are the OPs?
Only OP. Well, only one contemner is there.
Issue police notice. Same order. 16. Make out, Mr. Swain, give me a concrete case where I can direct arrest and detention of civil servants of higher rank.
Yes.
Give one such case.
Yes.
Yes.
Item 36.
My lord, kindly allow me from BC Barampur, my lord.
Yeah.
My lord, this is a case for regularization of service and payment from the date of transfer to date of joining, my lord. And representation is pending, my lord. That is NHS 6.
Petition prayer reads as that. Counsel for the petitioner submits that in terms of representation dated 10th March 2025 at Annexure 6, is considered justice would happen to his client, her client. First off. Learned ASC, AGA or ASC? ASC, Mr. Sen appearing for the OPs. OP numbers? Which OP?
1 and 2, my lord, both are.
OP. Submits OP numbers 1 to 4 submits that if a reasonable time is granted, there would be no difficulty for considering the subject representation in accordance with law. Full stop. With this, counsel for the petitioner is agreeable. Next paragraph. 8 weeks. Solicit. Yes.
Item 37.
Lordship, this matter pertains to the admission of the petitioner.
Kindly be loud.
May I please, Lordship? This matter pertains to the admission of the petitioner. She had opted for the round 3 counseling, wherein she was given a seat at the college in Haryana. As per your Lord,
Don't see you as per the order dated 14/11/25.
My Lord.
Have you served the copies?
My Lord, we have served the.
Order of this honorable court, my lords, we have intimated telephonically as well as by mail, ma'am. Yes, on the same days.
What is it?
My Lord, we filed a IA now. We intimated the college at Puri to take admission there. However, they denied us that there was no vacancy of seats. However, we were intimated by the OJE board that there is a vacant seat at Government Ayurvedic College, Balangir.
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 You will go there.
My Lord,
What do you say?
My Lord, we are to the deadline is.
I'm applying to the OJE, my lord.
Admit her in the Balangir,
my lord.
Balangir College. But this court made the following interim order on 14/11/2025. First of all, the college at the college at Puri
Yes, ma'am.
is stating that there is no vacancy, and therefore it is helpless. First off, Learned Counsel for the petitioner submits that there is a vacancy in the college at Balangir.
My Lord.
Balangir, and therefore her claim to be permitted to take admission subject to outcome of the petition. First one. Learned panel counsel appearing for
OJE, my lord.
OJE submits that this can be done if petitioner does not claim any equities during the hearing of the petition. First one. Counsel for the petitioner agrees with this proposition. Next paragraph. In the above circumstances, the college at Balangir shall give admission to the petitioner subject to all usual compliances. Within 1 week. Within 1 week. Not raising any issue, without raising any issue as to time bar, etc.
Deeply
Urgent
certified copy.
It will be given. Yes, next.
Deeply
Item 38.
Yes.
As per direction of SR, my lord, I filed 20191 of 2025 to change the nomenclature from WPC to CRLMP.
Criminal petition.
My lord.
WPC
as per the direction of as per the SR defect.
Matter has to go before
CRLMP.
Matter has to go before the other court after reclassification. Which court?
My lord, this is originally arising out of from civil dispute, my lord.
No, but criminal matter. No, section 107 of CRPC.
My lord.
That has to go before the criminal.
My lord, it will be converted to CRLMP, then the register will assign to the assigned bench.
The challenge is to the proceedings initiated under section 107 of CRPC stroke section 126 BNSS. Now pending on the file of Tahsildar cum Executive Magistrate. OP number? OP number, my lord. 4. OP number 4. First one. Learned AGA points out that the matter needs to be converted into criminal revision petition or criminal petition under 480.
Criminal miscellaneous.
Has converted into appropriate nomenclature and be posted before the roster bench. First up, ordered according.
My lord, it's urgent matter. That's why my lord may kindly take
Ordered
up.
accordingly. First off, order to be complied with urgently. Urgent. Okay.
Bless my lord.
Next.
Item 39.
Can I come back after a few seconds?
Yes.
Few minutes.
Services on the date of judgment and impose a cost of 50,000. There are two similar cases.
Yes.
We have complied all the orders within time immediately.
Yes.
So now we pray Lordship may consider to waive the cost of 50,000. We also directed to pay paid from the pocket of those of
Yeah, they should pay from their pocket, na?
No, that is true. So paragraph 4 and 5, they begged unconditional apology. It's
no,
not,
okay, what apology will help him? Why he should suffer?
no, that I understand. But he is in service.
Life is very
yes,
important.
no, I'm not there much. I'm not arguing also. We'll pay his dues.
Yes.
Within 15 days, you'll also consider.
They have not done it as it.
No. We passed the order regulation.
What dues? Whether the dues have been remitted?
No, he is in service.
All right. Whatever amount is payable.
That is being in the process, calculation will be made because
you bring all that first, make payment, put the money into the pocket of the citizen.
that will do.
No.
I'm not saying that your Lordship may dispose of. Lordship may observe.
Call this matter after
Yes.
2 weeks for consideration.
In the meantime, your Lordship may say his dues may be paid. That observation.
I should observe. No, I will not observe. Next date, I will dismiss it with again for cost. There is already order. How many plural orders? The court need not make plural order.
No, so
there is an order.
Immediately we complied to Lordship. Sort of passed order regularizing
the sea. That is the only way to tame people. Otherwise, nobody, because government lawyers will argue they have nothing to lose. They will pass all adverse orders. Sufferer is the citizen. No, that is not the way. Law of accountability is one of the features of the Constitution.
Yes, Lordship were pleased to
to be so declared by the apex court is another. But accountability is one of the factors.
Right.
Otherwise, they will become the officials of the East India Company.
Right.
Nobody will listen to, nothing will happen to them. That is the impression the bureaucracy has got. I have seen these people. No.
Lordship have directed to be listed 2 weeks after. Your Lordship may say in the meantime order be complied.
I will not say all that. There is already order. If you want to comply, all this. Otherwise, I will direct arrest and detention of your client.
No, Lordship directed for the regulation. We have done that.
You are not answering the question. Have you paid the money into the pockets of the citizen?
Yes, what I say.
What you say is it is being done.
No, calculation will be made from the date of.
Do all that and come back.
That one line observation will
no, I will not do anything. Why one line? So many lines are already written in the order. You are not compliant with what one more line will do. Yes, next.
Item 40.
Item 39, along with 11683 of 2024 will also be approved. Similar matter.
Which one?
Item 39.
39.
I would a similar matter.
The items to going on. Item 30.
Item 30?
39.
39. To be called along with that. Write down and give.
Sir.
Yeah. What order should be obeyed? That should be the culture. We can argue everything till we pass the order. Once we pass the order to jump from the 3rd floor, they have to jump unless it is stayed. Yes.
Item 40. Item 40, my lord, on the last occasion, my lord has asked for the submission of the tabulation register, my lord, of 1989, 1990
and 1991, my lord.
My lord, the staff of university, my lord, is there, my lord. With the security, my lord, there was some issue in the gate pass, my lord. For that reason, they have held up there, my lord.
Where they are?
In the High Court gate pass.
Send our police to permit. Yes, pass over.
My lord.
Has he brought these things?
Yes, ma'am.
Yes.
Item 41.
Acknowledgement of the pension and other retirement dues. I am before you, Lordship. Since 1990, I work as an assistant in the university. My
33 years you have worked.
And I have the entire service period has been regularized by virtue of the direction of this Honorable Court. However, they have not yet sanctioned the pension and other retirement.
Notice is not yet ordered.
Notice issued, they have filed a counter affidavit.
Who is their advocate?
Amit Kumar Nath.
Panel comes in from the
Who appears in this?
Mr. Amit Kumar Nath.
Amit Kumar Nath.
Nath, N-A-T-H.
Sister, bring him.
He was here.
Huh? You are saying, kindly bring him. I'll pass over. Yes.
Blessed.
Item 42.
42.
Wait, please, Your Lordship. I am appearing on behalf of opposite.
For that, the learned commissioner to visit and report. The report, I think, my friend is submitting.
Report now.
But
Lordship,
we be given a copy also of the report.
Given copy to you.
No, we may be given. I am praying before Your Lordship.
Let us do copy.
But before Your Lordship send the learned commissioner, the municipality are giving a statement before Your Lordship that we have removed that encroachment. What Your Lordship wanted a satisfaction through commissioner, and the commissioner was defeated. Municipality had given a statement. My learned senior Mr. P.K. Mahanti was appearing.
Wait, please, Your Lordship.
Mr. Mohanty was the commissioner.
Yes, madam.
What happened?
Well, so far the stilt area is concerned. That has been well maintained and is generally removed. And in 3 sides there are passages for so far the parking is concerned. Only that has not been numbered so far the pillar is concerned. But the block A left side it has been cleared out. And cementing the lower area. And
Your Lordship wanted I should cement it
we have
also.
given the candid photographs and the present persons from both the sides also and the flat owners at the page 11 and 12 below.
Whether police people helped you?
Yes, ma'am. Police, commissioner, and
police
also the
were
media
present
people also, they are all the way cooperated. And what I gathered information, my lord. Gathered the information. The plot belongs to somebody. The builder is somebody who has built this land.
And purchasers?
Purchasers are others. Fact remains, they are having the shares. So for the owner of the land,
owner share and builder share.
Exactly.
Okay.
Some of the flats has been sold out to X and Y. By
The
the
builder share or
exactly.
Okay.
Without
Without authority. That I am not saying here. Because it's not the-
out of that I have understood that this is the cause of discontentment. And it can be also amicable that we have observed also.
Out of 40-45, only 10, 14, 15 are valid purchases. Rest are not. That point I am not raising because it's a case of demolition, not those points Your Lordship may not. But my friend pointed out, I wanted to also submit that. Because by lot of... anyway,
Whether commissioner's fee is already remitted to them.
that was deposited fast, my lord. Your Lordship
But
direction.
that one we have got it.
You have got it. Yes.
But I deposited in time because I am bound by Your Lordship's direction, my client also.
What was the amount, initial amount was directed to be paid?
25,000 also. He has deposited, madam.
25,000. No, another 75,000 you give. No,
Your Lordship.
for 25,000, nobody will do that job. This is a...
Your Lordship will consider that it is so asking, madam. I have paid Your Lordship directed.
No, that is the initial payment.
It's a Bhubaneswar
How the
area,
order
my
reads?
lord.
How the order reads?
Your Lordship may see, my lord. Bhubaneswar area matter 25,000. My
No question is not just to leave entire
commissioner will agree that this is good enough, my lord. I don't think if the commissioner says this is not good enough, my lord, I have nothing. I will buy it out.
Another 25.
And we have met all. We have. I think. I do not know. I think the commissioner has been given all due respect he deserves. I
No,
think.
that you're bound to give
I
because he's
think,
the extended hand of the court.
No.
He's the extended hand of the court.
Absolutely, my lord. We have to respect.
Yeah.
And it's a coincidence that he was commissioner, I think, long back in one of my case. And destiny that he is again the same gentleman is the commissioner again.
Lordship, may I speak?
I am praying.
Lordship.
Now the commission report has come. Your Lordship may supply us a copy.
Lordship,
This might be
my
posted
senior
after
counsel is on his
the-
seat in another court, Lordship. I request for a pass over.
Copy has to be given to him. No, I cannot use the copy without keeping him in darkness.
And
copy.
And I
Give Xerox of that.
Man, and I humbly pray, my lord, so far as final hearing matter is concerned, lordship may keep it to after vacation. This is my humble prayer, subject to your lordship. I most humbly pray, my lord.
Keep that.
Because your lordship can imagine that I'm not also very well, and that is happening.
I'll give you time.
Last 15 days, my lord,
I'm giving you time.
Some issues or other.
Learned court commissioner. 2 or 1? The panel of learned court commissioners has submitted the spot inspection report with their observations, along with copies of photographs.
And the signatures of the president.
First, the merger report has been drawn in the presence of several people who happen to be the signatories as well. First, a copy of this report is served on learned counsel appearing for the petitioner on record this day.
Copy may be served to
For
the
learned advocates appearing in the party for the parties.
Municipality.
From this one.
All governor.
Give copies of the xerox. Yeah. They will give, just collect it afterwards. Okay? They seek some accommodation for arguing the matter on merits and to have their say on the report as well. First of all, the request is reasonable. First of all, call this matter in the 3rd week of January 2026. First of all, in the meanwhile, the petitioner shall pay a sum of rupees 25,000 to each of the commissioners, and report compliance, failing which he may not be heard in the matter. Okay.
I am paying 25,000 more.
To each. 25 plus 25. Yes,
man, that your lordship. Next, that will be little heavy, my lord.
Next.
But the interim order may kindly be extended.
Interim order to continue, subject to payment of the above amount. Okay.
41. There's been passed over.
Please come. Yes, 33 years of service.
Yes, sir. We have already,
and you have regularized also.
we have already paid the amount, my lord.
What amount you have paid?
My lord, you let me go to my counter.
Yes.
So, it is a flagrant case, and we have paid the area amount, all things in 80.
How much money you have paid?
We have paid already, my lord.
My lord, that is the area of service benefits, not the pension.
5 lakhs, my lord.
Not the pension.
Terminal benefits.
My lord, you let's see terminal benefit.
Kindly read the prayer.
Yes, my lord. My lord, if the state government is agree, it is state fund university. It is state university. It depends on state money. So the state government, if you agree, the proposal for any benefit of
it is our order.
Yes, your lordship has passed an order. I have seen sort of a case.
Read that order. Does it make the state government's fund dependent? If there is an order, you have to sell all your furnitures and pay.
In the above,
unless order says otherwise. What is the order? Read the order. 33 years of service the employee has put in and no pension is being paid. After having regularized the service. Read the order.
In view, my lord, in the South America case, my lord, in view of the circumstances, the petition subsidiary circular issued passing the employment order dated 6/2/2014 to the extent to fix the petition effective date of regulation in 18/3/11, coupled with the direction of fixed 14/2/92 as of date of regulation. Further, the petition shall give the national benefit to the statutory regulation till 12/2020 under monetary benefit with effect from 11/12/2022. So far, after financial aspects are concerned, it hardly needs to be stated the opposite party, number 4, has to pay appropriate budgetary allocation in this regards. Completion of in 3 months.
But terminal benefits not included. It is only regularization benefits. That is the order.
Yes.
If they are not given pension and other thing, it's a fresh cause of action.
Yes, for which I am before your lordship. And I have also approached them that you pay me, and similarly situated person have already been paid by virtue of the direction of this honorable court. Yes, the reasoning, my lord, given by the opposite party, your lordship may kindly turn to page 3. Page 3 of their counter affidavit.
No, your prayer in the petition is, let us go to prayer first.
Yes.
Sanction and release of pensionary benefits. Now, what is your answer to this?
My lord, we have paid the area amounts, my lord.
You are not, do you understand?
Yes, my lord. Yes, my lord.
Have you
Let's
paid?
assume the area pensionary benefits, my lord.
Is it pensionary benefit?
No.
Don't mislead the court.
My lord, your lordship, Pastor Shalachandra
We are not concerned with that all. This is a fresh cause of action. Petition is filed. Kindly read the prayer of the petition.
In respect and purposes of the case, the petition respectfully pleads that the Honorable Court may be granted pleased to admit the writ petition, issue notice to opposite parties to show cause as to why the recommendation dated 4/3/2024 under answer 7 has not been taken care, and if the opposite party failed to show cause or show insufficient cause, the Honorable Court may be further pleased to allow the writ petition in issuing writ in the nature of mandamus or any other appropriate writs directing the opposite party to take immediate step for sanction and release of pensionary benefits within. Yes.
So, case relates to, let us understand the case. This case relates to not regularization, nor payment to be made or that has been made pursuant to regularization. This case relates to sanctioning and release of the terminal benefits, which will include the pension. Is it correct? What is your stand? Why pension is not being paid?
We have not paid to pension because it is a block grant. It is a block grant, madam. It is a block grant added from the university. The petitioner released his salary as per block grant. If the pension or any, it is not 1%, that is 100%, near about 100%. We have not denied to the person who is servicing the service. We have not denied. We ready to pay. But government is the university.
Government is also a party to this.
Yes,
my lord. What has happened? My instruction is that government has already allocated the fund to the.
Therefore, I asked you: is the government a year nominee party to the proceedings?
Proceeding in this case, my lord. No, it is.
Then you inflict the government. Let us have their version.
But
if they say we have already released.
But one more thing, my lord, may I submit? Irrespective of the stand taken by the university, some of the employees, I have for them have already been paid the pension.
Anyway,
that was never the stand taken by the university.
No, anyway, they are saying, have you taken up the stand? Government has not given money and therefore we are.
Yes.
Only they have.
No, we have taken the plea that it is state government. Your lordship would para 8 of the account. The state government.
Paragraph 8.
The area salary of the petitioner was paid to him out of own fund of the university. It is ought to mention here that the Utkal is a state funding university and it depends on state government funds released to through annual block grant to meet the annual salary component and pensionary benefit to regular non-teaching employees, my lord.
Para 8. Para 8 of your
last portion,
yes.
Paragraph 8, last portion. It is worthwhile mentioning here that the university is a state funding university and it depends on the state government's fund released from annual block grant to meet the salary components and pensionary benefits of the regular teaching and non-teaching employee. The regularization of the services of the petitioner has already put pressure on the university's own fund.
Yes, you add, I will direct you to add the state government as a party to these proceedings. You do that so that we will have their version. Then we can block their contention.
Yes. My lord, your lordship may allow me to.
I will direct you to implead now.
Implead, my lord, through in the court.
Yes.
Right now.
Right now. Perfect.
I petition so that it is.
No. Why? File petition. Once again.
This court has power to add anybody. Yes. At para 8 of the counter, the university has inter alia pleaded that it depends upon the funding by the government for considering the claim of petitioner for sanctioning the terminal benefits. First one. Therefore, the government, being the funding agency, arguably,
Finance Department
answers the description of proper party, if not necessary party, in the light of Apex Court decision in 58 Supreme Court. A or 58 50. What is that judgment? From Begum. Rajia Begum versus Swine.
Rajia Begum.
First off, in view of that, petitioner is directed to array the Secretary, Department of Finance, any education, etc.
Yes, we want finance all and also higher education.
Higher education.
Yes, ma'am.
both.
The
Finance, it
Secretary,
will be-
Department of Higher Education, as OP number so and so,
3 and 4.
and Secretary, Department of Higher Education, as OP
Secretary,
number
Commissioner cum Secretary. Commissioner cum Secretary.
Commissioner cum Secretary, Department of Higher Education, as OP number 4. First off, petitioner to amend the cost title. Mr. AGA, Mr. Mohanty is requested to accept notice for the newly added OPs, and file a counter within 2 weeks. First,
Yes, today I saw the copy in course of the day.
amended petition along with all the documents on learned AGA immediately before sunset of the day. First off, if that is done, call this matter in the second week of January 2026. Okay.
God bless.
Next.
Item 43.
May please, Your Lordship.
Yes, sir.
Lord, it's a case when the petitioner was appointed under the OCS Rehabilitation Assistance Rules 1990.
My lord, here is a case. The petitioner was.
He wants to say something with the leave of the court. Yes.
My lord, he was appointed under Rehabilitation Assistance Rule 1990. To meet the emergent need, he was engaged against a scheme, that is non-formal facilitator scheme. On closure of the scheme, my lord, on last come first go basis, the service of the petitioner was terminated. Again, he was re-engaged. He is claiming salary for the retrenched period. Yeah.
Interregnum period.
Interregnum period, retrenched period from the appointment period. Re-engagement debt, my lord. That period he has not worked. So our contention is no work, no pay, that period will go. But this honorable court has passed an order saying that to pay salary, actual benefit shall be given because it is termination was illegal.
Once court says,
My
it will
lord,
be wrong order.
he has not worked for the period.
Kindly be seated. I will not pass any adverse order against you unless you disturb me. Yes, kindly be seated. I will not pass any order against you without hearing you. Yes. Yes. Now, there is rightly or wrongly, there is
an order of the court, my lord.
Has got power to pass right or wrong order.
My lord.
If it passes a wrong order, nevertheless it is an order. Unless you get it vacated or otherwise modified in accordance with law.
The court has passed an, should I place the relevant portion of the order?
Yes.
Claim of the petitioner.
Page number?
Page number, it is 5.
Page number 5.
5. The order passed in WP OSC number 912 of 2001.
By the coordinate bench.
By the coordinate bench, my lord. Honorable Justice.
So. No, need not name the judge.
My lord.
Yes. Yeah.
Para 9, my lord.
Para 9?
Yes.
Let's see, lot of rejection.
Claim of the petitioner for back wages for the period of wrongful termination
till time of reappointment by adjustment appears to fulfill all the conditions necessary for court to direct entitlement and payment. The period that petitioner remained under wrongful termination was on and from 1st April 2001 till 24 July 2003. Petitioner approached the tribunal by this writ petition on 11th April 2001, the day on which the tribunal was made observation regarding.
Where are you reading?
Paragraph 9.
That order is not part of the proceedings.
May now, my lord, permitted to submit, my lord?
No, I'm asking you.
My lord,
Is it part of this proceeding or not?
This is in my pleadings, my lord. I am giving the copy, my lord. I have, as because I have supplied the copy earlier, my lord. That's why he is submitting without the copy of.
Yes,
my lord.
Paragraph, sir?
No. Paragraph 9, your lordship. I was listening. दिया मते पटे देऊ देऊ paragraph 9. That petitioner remained unemployed in the period and thereafter. Therefore, there cannot be mitigation is proved by entries in the order sheet and the petitioner's prompt acceptance of his adjustment to be reappointed. There will be order in the writ petition to give the petitioner back wages for the period from 1st April 2021 till 24 July 2003 at the rate of the petitioner, then drawing his salary and emolument, if any junior clerk appointed under this rule. The aggregate of arrear back wages shall be disbursed to the petitioner along with back interest on yearly.
When interest is ordered.
My lord, I am humbly praying that the interest portion may be considered, my lord.
That will consider, but make payment first. First you should, it is like saying, it is my principle not to pay the interest, and it is not in my interest to pay the principal back.
No, my lord, let's
get the principle, right? Say, mitigate this one, then we will consider that one.
My lord, let's dispose of the matter accordingly.
Why dispose of? You bring check next day, otherwise I have to impose cost and other things. No disposal. Disposal has never helped any citizen. That has not helped. That will be a paper tiger. You bring money, put it into the pocket of the litigant who is victorious in the litigation, legal battle. Then we'll close the matter with that. And we may give some concession in interest also, if subject to what he will say.
My lord, lordship may then give me some more time.
So that which date you want? On that day?
Second week of January, my lord.
Second week.
Second week of January.
For making payment.
Unless your lordship directs for payment, how can I?
There is a direction. How many directions you need?
My lord, there is a direction so far as another case, my lord, Pradeep Kumar Panda.
This is not his case.
No.
It is another case.
This is
similar matter.
Similar matter.
Then we'll say, sorry, it is covered by the judgment.
Yes.
Same benefit has to be given to you for that particular period.
Lord, now may I be permitted to submit, Lord? In this case, my lord, that was what my lord senior friend said, that the petitioner was appointed under the Rehabilitation Assistance Rules 1990, my lord. Terminated due to a schematic appointment under MFE. That was challenged, my lord. And in this petition, which is covered, my lord, that judgment, that was answered in 2000, my lord, 21, my lord. Thereafter, for another 3 years, I moved on 3 contempt petitions. Thereafter, they have paid with interest, my lord.
They have paid it?
Yes, my lord. That has already been complied. Now, in present writ petition, my lord, the petitioner, your lordships may kindly just to index page, my lord, of my petition, 4th round litigation I have moved before this court, my lord. 3 times this court, time and again, approached this case is covered by this judgment, you pay. Consider his representation. According to this, they have rejected. Time and again I have approached. Now, on the fourth round of litigation, my colleague is asking for removal of the interest, my lord.
That is prayer.
My lord. Besides that, my lord, I have much more time before I have supplied the copy of the cover judgment. That is not of this case. This case covered under that judgment. My learned friend, what he has submitted, he submitted the case from the judgment, not from the case. That's why I was misunderstood by your lordship.
No, I have not misunderstood.
So
I only requested you
Miller,
that he wanted to
then my humble prayer, Miller, the date of termination is same. The date of the grounds taken in both the cases, in all these cases
in
are
other
same.
words, it is covered by this judgment.
Squarely covered, Miller.
I want to pass order if you permit.
Miller, with another prayer, Miller. All with other consequential service benefits. That means seniority and other things.
That will give.
That you have to give.
Yes. Miller.
Disagree.
Oh, blessed Miller.
Still you want to argue?
No, man.
But we had anxiety because too many times he was in the court.
Yes. Throughout the state, this problem has arose.
Some lawyers will have some anxiety because their clients are so many times coming to court. This is not a happy place.
Fourth round
this is a place of negativity. Court is a place of negativity. And lawyers, by their excess argument, will add to the negativity. Yes. Go to the prayer column. Petition prayer reads as under. First one. Learned counsel for the petitioner submits, and learned AGA, Mr. G, appearing for the other side, does not much dispute that the subject matter of this petition is substantially similar to the one in WPC OAC number 912 of 2001 between Pradeep Kumar Panda versus State of Orissa, disposed of by a coordinate bench of this court, wide order dated 2/12/2021. And therefore, the benefit accorded to the litigant in the said case has to be extended to his client, who is similarly circumstanced. First off, he also adds that the said judgment did not cover, in so many words, the direction for grant of consequential service benefits such as seniority.
Seniority and increments, annual increments.
And accrual of annual increments. And therefore, that also should be extended to the petition, granted to the petition. First off, there is force in this submission. Next paragraph. The coordinate judgment at paragraphs 9 and 10 read as under. Next paragraph. In the above circumstances, this petition succeeds. A writ of certiorari issues quashing any quashment orders.
Miller, Annexure 2 and Annexure 7.
Quashing orders dated
31st March 2001, Miller.
31/3/2021 at Annexure 2.
Annexure 2, Miller.
And
rejection order dated 30th April 2024 under Annexure 7.
Slowly, she has to write down now. And order dated 30 April 2024 at Annexure 7. To the extent the same related to the petitioners.
Miller.
The petitioner. First off. Next. a writ of mandamus issues to the which OP?
Lord, OP number 3, my lord.
OP numbers 2 and 3.
2 and 3, my lord.
2 and 3. To grant all benefits as are granted to the litigant in the coordinate petition, and further the benefit of service, back service, such as promotion, increments and promotion. No promotion.
No.
Seniority and increment, annual increments.
Consequential benefits.
By way of consequential benefits. First off, this order should be complied with, and compliance report should be filed with the Registrar General of this court within an outer limit of 3 months. 2 months.
3 months will be. 3 months will be.
Within 2 months, let it be. If you need any extension, let us consider within a period of 2 months. 8 weeks, 8 weeks. 8 weeks. First off, interest payable is at the rate of 1% per mensum. First, the interest component may be recovered from the officials who are responsible for the giving of cause of action for the subject petition.
If not complied, my lord.
What if not complied? Interest has to be paid.
No, my lord. What I am submitting, my lord. If not complied within the time stipulated by your lordship, 8 weeks or what should?
No, interest should be paid from the back date only. As is mentioned in here, in this one.
Right.
The reckoning point of the interest is the date on which the amount was otherwise payable to the petitioner. Okay. Yeah, call them.
Miller, next item, Miller, therein, that is WPC.
Similar,
Miller.
Similar.
That
Same
is Miller.
The subject matter of this petition is substantially similar to the one in
17,000
WP number
17436.
17416
of 2022.
of 2024 between the same parties, disposed of by this court, this date, wherein the operative portion reads as under today's operative portion. Next paragraph. In the above circumstances, the relief as has been granted in the said petition is extended to the petitioners with the same terms and conditions in this petition as well. But that is, and this. Okay. Okay.
Item 40.
Yes.
Sorry, my lords, my officer could reach in 5 minutes.
No issue. Yes.
Has directed the university to produce the PRE. Our case is very simple that it has not passed the examination. BA examination. Back paper examination. So the total he failed in BA examination. My lord directed to produce original of 8990 and 90 year of now 8990 and 1991.
Correct.
The deputy controller is present, my lord, has come up with the record.
Kindly sit down, Mr. Controller, Deputy Controller. Kindly sit down. No, you can have him behind you so that he can assist you, instruct you. Yes. Somebody may yield the seat. Yes. Yes.
1989.
Can you take Xerox? Take Xerox and
They have given that copy. The college has given that copy of TR register because it was communicated to them.
No,
1989. That is there in the record.
In the record also. He did not appear. It is not entered here.
No, he 89-90 failed.
He failed.
She failed.
Where is what is his number?
Number, my lord.
What is the prayer of the petitioner?
Your prayer is made for a direct issuance of direction to open number 1 to issue the original +3 final examination certificates of the petitioner. She has passed the year 90 in the year 18.
There is no reflection. In this, there is no reflection that you appear for the, you passed the examination.
In the body, I have abhorred in the body.
Huh?
In the body, this fact is abhorred in the body. In this fact is pleaded in the petition. This fact is pleaded. She appeared in the year 89. She failed, and they repeated the back paper. And in the year 90, she passed. And after passing,
in 1990, she passed it.
90. Well, in the year 90,
TR register does not show her name that she has passed.
Your Lordship.
And the most on register. This is 89-90 minus wanted 2 years.
2 years I want.
Yes, 89-90.
You have failed and you
Yes,
that.
Yes, I do.
That roll number.
I don't need now.
But now 90. 90 minus also doesn't reveal so.
Show that. Original.
Original.
Yeah. 1990 is how many years? Is it 30-year-old now? Can I raise presumption of correctness under section 90? This is original record.
Original record. Because some
number is
number, but there is here no number is not there at all.
If she had appeared, that number would have figured.
Would have been figured there, and this could have been a copy of this should have been communicated to the college to issue the birth certificate.
In terms of that.
But
that
the college
says
the college case is that they received that provisional certificate and mark sheet. That is how they issued this. I think this university.
I am appearing for the college.
Also online. Thing is that manners. Suppose we are not issuing the TR register. The college is issuing that provisional register. They say that these are all recorded in our register. They don't say, but in so far that RTI information the petitioner called for, they categorically said that TR register is not available. If we suppose we are considering for the sake of argument that yes, they have received that provisional of all these things. They cannot say that. They have to act upon the TR register. Well, the university matters, I talked with the registrar and vice chancellor. They said that it is most alarming matters that it should be required, it requires a detailed inquiry matters.
Investigation
by an independent agency.
Yes, you will submit it.
Independent agency. It itself to scope.
We are not opposed to that direction. But in the 89, in the year 90, she appeared the back paper by one admit card. That is that admit card roll number. As per that admit card roll number, examination should be made because that they different his roll number which was allotted for appearing the back paper. In fact, the university is not making inquiry with reference to that back paper number because she appeared
back number.
That back paper, that admit card by which she appeared the back paper, that is very much annexed with this with the rejoinder of this petitioner or annexed 2, wherein that is 121B041 bracket B. That is the
Can you look at that? It is there.
What happened after passing?
Can look at if it is there, well, this number.
No, that is not there.
That is not there.
After passing that back paper, they have issued the original certificate and original certificate. In the original certificate, the provisional certificate which was issued by the university. Let me complete. The original certificate which was issued by the university and sent to the college, whereafter college has given the same to me, this petitioner.
Is it true?
Yes.
No. Original certificate has not been issued.
That provisional certificate.
Only
provisional certificate.
1 second. The provisional certificate is given by
Yes, sir. Provisional certificate is issued by university.
In that. You took the second examination when?
In the year 90.
Reappearance.
This is
It's a reappearance.
back paper.
English paper 1, paper 2.
Back paper?
English paper 1, paper 2
for
1991. For
the year 90.
He failed in 1989.
89 appeared the
Petitioner failed in 1989 examination in English.
Paper 1
entire. In English.
Totally failed. English paper 1 paper total failed.
First. He or she wrote back papers English 1 and
English paper 1 and paper 2.
English papers 1 and 2. In
the year 90.
In the year 1990.
Bracket bells back paper.
Back examination.
That
why the registration number?
They say registration number
12. Registration number
121B 86041.
Registration number.
Registration number
231.
This is roll number. This must be roll number. The roll number, they have to refer to roll number, not registration number.
Roll number is different.
Roll number is different. Registration number is different. Registration number is allotted to one student.
Once. You tell registration.
Yes. Registration number 231 63 oblique 86.
Oblique 1986.
Yes.
Only 86.
Because he belongs to 86 batch.
And roll number?
Roll number, she appeared the back paper 121 B 041 within bracket B, but B.
Capital B.
Within bracket capital B.
But kindly look at under the mark sheet they refer to. That refers to a different roll number.
Which is that?
That is 121B. That's my the repetition page number 8.
That admit card.
121B 86041 page number 8.
121B 86041.
Yes.
It's a different ratio.
86 number. That provisional certificate whereon this roll number is stated, that roll number is 121B 86041.
Yes.
And 86, why 86 is mentioned? Because she belongs to 86 batch. Therefore,
is it mentioned?
Well, that I have given the admission register.
That admission register.
Come to page 8 slowly. Come to page 8 and read slowly now.
Yes.
Me.
Yes.
Page 8.
Page 8.
This 121B 86041.
Yes.
What is that number?
That is the roll number of the candidate.
1 second. But which one you have given to me now?
Now that number, that same number was given. That is the roll number. That is the roll number.
1 second.
Which is
121B 86041. Correct?
Yes.
What is your contention, sir?
My contention is that where is that figure? Page 7.
Page 7.
It is in the.
That is the provisional.
What is that roll number?
Provisional certificate.
This roll number is not visible.
Second paragraph. It is also there.
That same roll number. Earlier, my learned friend referred to another roll number. Now they say the same roll number.
Same roll number. Understood.
Yes.
Now, are you agreeable for a CBI inquiry?
Yes. I am ready. I am agreeable. Well, what happened? Yes, what is it? We are not opposed to that. The provisional register which has been produced by the college. Why your lordship 86 number is added? 86
Because he has taken admission in 1986. I have given the extract of the admission.
Do you support the case of the petitioner?
Well, I am not supporting anybody. Whatever records are there in the college.
No, according to what records say about version of the petitioner?
Yes, my lord, my version is the present principal has joined in that college in the year 2022. But this has happened in 1990.
Yes.
But I have given the extract of the admission register of that candidate.
As is available.
Yes, which is available. Then, my lord.
Where is your original admission register?
Yes, original admission register.
Show it to me.
Principal has come. The present principal. Yes.
Others may come after in the second session. Sir, you come in the second session because this matter will take some time. Yes. Give them.
Kanaklata Sama.
This appears to be original only.
Yes, yes, original. Kanaklata Sama. The name of the Kanaklata Sama.
Admission. There is no
Admission list.
There is no dispute about that.
Was admitted.
Admitted in 1986.
But whether she passed in the back paper examination is the issue.
Yes, that is the
That is the issue.
That is the issue.
We have to resolve that issue.
My lord.
That has to be on the basis of university records.
University records.
Because for admission there is no dispute at all.
There is no dispute.
She was
at all.
admitted, she failed.
Yes.
In 1990.
89.
Subsequently, her case is that she passed.
Passed in 1990.
Where is that? On what basis you failed the provisional certificate?
Provisional certificate. Yes.
Yes.
My lord, your lordship may kindly see. My lord, a communication was made. Our stand is.
No, many records are there for the stand. Only argument.
My lord, the later dispatch register is there. And in the later dispatch register, my lord, her father has received the provisional certificate from the college. That endorsement is there. That
No,
much.
you will prepare the provisional certificate on what basis?
But we cannot prepare. The college cannot
basis
prepare.
of university, you have to do everything.
University is supposed to send it to the college. And thereafter the college hands over the same to the concerned candidate. That is the procedure.
That is the procedure. Where is the university sending it to you?
My lord, at the relevant time, that is in the year 1990, my lord, that provisional certificate is not available in the college.
No, records showing provisional certificate was received from the university by the postman, through the postman, through the horseback, through the pigeon. Where is that?
That later dispatch register, your lordship.
Letter dispatch is to the parent of the ward.
Yes, yes.
No, I am
kindly
asking.
see.
That does not serve. Question is,
yes,
it shows that you have given it.
Yes.
Where is that you have received to give? That is not available. Is a new principle.
Yes.
In the college, you do not maintain the register as to the intercourse between the college and the university. No, 1 second. Do you know English? You know English. Small sentences and forming. Who issues the degree certificates?
The university.
University. To whom it issues? College. For college having received it from the university, do you maintain register or not?
He has given a PR, abolition register. 1990. He has filled.
Correct.
I have the PR.
Correct.
That I have given.
There is no dispute about that.
1990. There is a abolition register is not issued to university to me, college.
It is not issued at all.
No.
Then how could you issue the passing certificate to the parent?
Sir, only provisional and mark sheets provided to me.
Who provided that mark sheet?
Sir, university.
Where is that record? That university sent it to you on such and such date. You will maintain the register. Under the university regulations.
Only TR there. But in the year 1990, there is no TR available in the country.
Then how could you issue the certificate at all? Not you, your predecessor.
Yes, predecessor.
On what basis?
I also failed to understand.
But the records show. But why I don't want to see, I am little.
Well, this is the letter dispatched yesterday.
That is the letter which you issued to the parent of the ward. I understood that.
Yes.
Question is not that. To issue this, it should come from university.
Yes. That is the procedure. That is the procedure. That is the procedure.
If I direct the CBI inquiry,
yes,
the interest of the student may be affected, because in all appointment circular, notices, etc., there is a clause. Were you involved in any CBI police investigation? Then she has to tick mark that yes.
Yes.
That I am little worried.
College is concerned.
The college also will if that is a thing, then I direct the government to stop. It is a government college or aided college?
Aided college.
Then I will direct the government to stop the aid to such college.
But this thing has happened back in the year 1990.
Correct. But now, what is here, your records are here.
But that principal is dead. The principal
we are not against, we cannot go and dig his grave. Whatever records you have, you are producing it for me. As per the records, I will go.
Yes.
My only anxiety is, in the best alternate, I will give one more option to you.
Yes.
You appear for this examination again.
What has happened?
1 second. You appear for the examination again in the next examination, which shall be treated as the examination of 1990 itself.
Yes.
In the special circumstances.
What is the problem? So you also may permit me to make some submission. Because in the dispatch register, actually the dispute arose. My lawyer friend is disputing why 86 number is added in the in the dispatch register. So many students have been issued their provisional certificates. The copy of the same is produced before lordship by the college, and all the roll numbers, people lordship will observe. That all the roll numbers 86 is there. And all the students have been issued. C belongs to 86 where there is no dispute. And your lordship can see, after passing the BA examination in the year 90, in the year 92, she was allowed to appear MA examination in the same university.
But university will not verify that the certificate are usual basis.
The student is allotted one registration number. Whenever a student appears the higher examination, the university has to makes the inquiry with reference to that registration number, whether she is a student of this university, whether she has passed graduation or not.
Which rule? Which rule?
But
which rule?
There is one judgment that aspect has been dealt with.
Government give that.
That aspect.
You presume certain things. Give the rule position. Give the judgment.
In one case, that judgment has been also rendered. I will.
What is the difficulty now?
Now, Millard, at the now, 30, 90, 80, 90 she has passed.
Yeah.
Meanwhile, 35 years have passed. She is now, her age will be 54.
What is she doing now?
She is now working as a Anganwadi supervisor and Anganwadi worker.
And break slowly. There should be full stop, comma, etc. Not to you. In schools. Yes. Now, whether your job will be in stake.
Millard, no, job will not be in stake, but she will be deprived of promotion. Why this certificate is needed? For the purpose of getting promotion to the post of supervisor, that original graduation certificate is required to be seen by the authority. That has to be considered because a person working as a worker, unless he is a graduate, cannot be promoted to the post of supervisor. That is the reason for which that certificate is necessary. In the year 2012, when that her case came out for consideration for promotion, she wanted to be issued the original certificate by the university, for which she made an application to the college in accordance to the procedure, and the college made an endorsement therein that she was a student of this college. She has passed the graduation in the year 90, and according to that application was submitted before the university with the requisite fees. University went on sitting over the application up to the year 2016 without responding to that. In a compelling situation, she approached this honorable court in the writ petition wherein this case is now pending. And ultimately, OP number 2 was also added, and in subsequent period, in the year 19, they filed a counter stating therein that she has failed. You will also may kindly observe, from the year 2012, she applied for a certificate. In the year 19, they said that she has not passed. And in subsequent period in the year 2024, when the honorable court said that you have filed a reply, they are saying that she has failed. But you are not disputing the provisional certificate and mark sheet which have been issued to the candidate through the university, through the college.
That they are not agreeing.
Thereafter, they replied that certificates appear to have been forged but not corrected.
Where is that?
They have taken that stand.
Show that.
Yes. My humble submission, people are.
Please show your argument.
Yes. Yes, Milord.
I'll come at 2:30, 2 o'clock.
Yes,
perhaps 2:15 I will come back today.
Yes,
I have to sign some judgment, and therefore I will take 15 minutes more.
All right.
Yeah. Or I'll come early by 2 o'clock, but I'll raise little early.
Yes.
Okay? Just give them back. Her promotion depends upon the.
This is graduation certificate. That is necessary, Milord.
You give me some time. I will have some discussion with my brothers. This is a complex case.
Yes.
Yeah. Suppose if I deny relief to her, she may feel I am an innocent. There may be mistake with the college. Why I should suffer? If I give relief to her, university may say our records say like this, and still judge is granting relief. I am in a fix.
May I submit one thing? I will point out two things. Let us see how the petition has come up in clean hand. Well, kindly see, but I pointed that deputy controller I pointed out just now. Of course, I have not taken that stand, but that spelled out from the document itself, I referred to by the petitioner. Well, kindly have a glance to the admit card, which my learned brother referred to and relied upon, that yes, she has appeared the examination back paper.
Admit card.
Admit card issued, basing upon which unless an admit card issued, no one can appear the examination.
Puskal admit, the university admit that.
Admit card.
1, 2, 1, B04, 1, 1, 1, 2, 1. B04 or 8048?
So that number,
that back paper.
Number correct.
Admit card. Regender. Well, so that is in regender.
Is it your case that she did not take the examination?
Yes, that cannot be possible. Perhaps. Well, kindly have a class 2. Where this you pinches marks, I wanted to get it from the deputy controller. And now minus I am pointing it out for minus. Well, kindly have a class 2 page 13 to the regender filed by the petitioner on 27/1/2020. Next, that is page 13. Minus,
this is the according to petitioner, this is the provision that this is the admit card issued by the university to appear the examination, back paper examination. Now kindly look at that roll number 128B041 back paper B, bracket B. Bracket B. But that is not very important matters whether roll number is wrong or right. I'm not on there. Then I kindly come to examination.
Examination.
BA General back paper 1 and part 2, 1989.
That is the back paper of 89.
That was of 1989.
Yes, that the controller says it would be back paper examination 90.
No, it cannot be.
How cannot be? Please, sir, university, the experts, I am not standing in anybody's way.
Is right. 1989 was the regular examination. You did not write back paper at all. You wrote the back paper only in 1990. How can it be 1989? It cannot be.
She passed, she failed in that paper. She appeared the same examination as back paper.
When?
That is why this admit card was issued.
When?
In the year 90.
Well, this is of which year? Can you see that?
This is the 89 and examination was held in the year 90.
1 second. If it is 1989, why the back papers?
89, when form fill-up was made for the back papers examination, this admit card was issued in the year 89. In fact, exam was held in the year 90. And she passed in that examination.
What is the
this document is not disputed in the counter.
No, I'm not.
They have examined and what is the date of this letter?
That also is not seen, my lord. That is not there, my lords. That is not there. That is not found, my lords.
Where is
space for space for?
Where is your original letter? Where from you have Xerox these things? You produce the original letter. Give the original letter. Give the originals?
Yes.
Let us see the date. Because arguably that also can be argued.
Now that can
what he say also may be true. Because this is of 1989 examination.
May I submit one thing? I got this information discussed with the deputy controller today, my lord. Fairly I'm submitting that. That is what he pointed out.
Kindly give the date of test.
I am passing on all the documents, original documents.
The simple facts create complexity.
I know.
This is original.
That is not available. The original I found out, that is not available. I found
these appear to be genuine documents. I don't say original, etc. They are all genuine documents.
No, that must this application that admit card minors that is there.
Admit card is also
that is there. I'll point out another 2-3 things minors for minors consideration. That doesn't contain minors. That probably that may be in the
very old
one that may be minors. Then minors.
A candidate does not appear to be fraudulent or something like that.
Minors, I am not on there, but things happen.
Because all these, kindly see this. All they are very old. If they wanted to play mischief, etc., somewhere they would have left the some track they will show.
No,
But all these are
that matters I will point out on.
these are all genuine documents.
I will go through that whether university. The question is that my lord.
That is number one.
The university.
No, I understood the point you have said now. I was also a para-academician for many years. I was a teacher. So now difficulty is, it is quite possible that your officer might not have made an entry correctly. It is quite possible.
That is there. But fact remains, I understood that it might, I could have considered to that.
Number two, I am telling you, when she made her value addition in your university.
Value addition means that I'm coming back.
Yes, that time.
That I'm coming to that.
You should have told. No, you have not passed it
exactly. I got that information also. I'm pointing it out. Before that, matters may I point out page 17. The mark sheet they refer to and rely upon. Only I pointed on. Maybe minors I don't dispute because the documents minors, those who have supplied to him, the college has supplied to him. These documents might have changed up to 89, 90. So we are
I'm not finding fault with the university also.
No.
Some fault appears to be with the principal.
There is rightly minors point out there the shoe pinches. And it was going on then minors, then let us not discuss on that, more on that, minors, let us not discuss. Because the principal is not there.
One thing I will bring to your lordship's notice, in the same year.
You have issued so many people.
Yes.
That is not dispute. No. Frauds are committed that way only. The frauds are not committed in a wholesale way. Always out of 100 notes, only one note.
No. Exactly.
Your lordship, may kindly say, she was not the solitary student of that year. Other students were also there. So without issuance of tabulation register, those 2 or 3 who have appeared in the back paper, well, those certificates are also available in the college.
No, that is exactly, you must be having that the TR register.
No,
anyway, let us not point on that now.
One second. No. Whether the authority which should give you promotion, is it insisting upon the original?
Yes, that is necessary. But yes, that was being insisted, but at present this is now not be required, and my promotion has not been further consideration because of thereafter I am now continuing in my original post without promotion, and I am about to get promotion. But this is the requisite qualification for promotion.
MA you have done.
Sir, very interesting aspect of your lordship has to consider this aspect. Unless I have not passed graduation,
how do you go to MA?
How she was allowed to appear MA examination as a private candidate in the year 92 in the same university, and the admit card was issued, and that admit card which is enclosed and produced before this Hon'Ble Court has not been disputed by the council for the university. That apart. No, I request lordship to observe the conduct of university, because in the year 1960 she was allowed to appear bid examination as a private candidate. At that time, necessary verification was made by the university with reference to the registration number allotted to the candidate, and she was found.
One second. Now, the whatever documents you have, let the promotion authority consider it. Without
don't have an objection to that.
Without insisting.
Yes, Miller.
Because we cannot go back in the history.
Yes.
It's now a long period, about 3 decades are over now.
Yes. I do it university, now 2 years service for left for retirement.
Okay.
I don't stand in the way, minor.
Correct.
Somebody gets benefit, minors, why shall I start? I should not. Only 2
that way I will make observation.
Yes.
Only
that will solve the purpose.
Much water has flown.
Now, kindly be seated.
Yes.
This is only to do justice. We have taken oath to do justice.
Yes.
But sometimes we do justice little this side, that side.
Yes.
The essential grievance of the petitioner is as to non-furnishing of the original educational certificates and marks cards by the OP University for the academic year 1986 to
1990.
1990.
no, that was academic year was by that time over 86 to 89. 86 dash 1989. 89. First off, these educational records relate to what you call it as back paper, something you said. I did not know that. Back paper examinations in English 1 and 2. First, the college in which kindly be seated, in which petitioner had prosecuted her course has admittedly issued the marks card and provisional certificates, presumably on the records submitted by the received at the hands of the university.
Yes.
Very much. First. Next paragraph. After service of notice, the university and the college affiliated to the university have entered appearance through their panel council. First off, the learned senior counsel appearing for the university, having filed his counter, vehemently resists the petition, contending that for the year concerned, the original registers maintained in the university, tabulation register maintained in the university does not reflect the petitioner taking supplementary examination, back paper examination at all. And therefore, if the college has rightly or wrongly issued the provisional certificates and marks cards,
CLC also.
CLC and
College living certificate, the
CLC and conduct.
What all?
CLC conduct
pass the examination
certificate.
Once he passed the examinations, college living certificate is to be given.
Kindly repeat.
College living certificate.
Only college living certificate now they have
college living certificate, provisional certificate, and marks.
What you have written there? Issued the college living certificate,
provisional
certificates,
conduct certificate,
and marks.
And provisional marks card.
Yes.
The university cannot be faltered. First one. Next paragraph. Learned panel counsel appearing for the college vehemently opposes the petition. No. Maintaining the equidistance between the parties, submits that the college records which are more than 30-year-old reflect the claim of the petitioner to be genuine to the extent that the issuance of college leaving certificate, conduct certificate, provisional certificate, and the provisional marks cards. First up, he also tells the court that at this length of time, whether the candidate took petitioner was issued these certificates these documents on the basis of records of the university, is very difficult to ascertain. Much water having flowed under the bridges. First up. He adds to this, learned counsel for the petitioner adds that his client had prosecuted higher courses, namely MA
and BD.
And BED.
But she has not.
Years ago.
In private courses.
As private.
As a private candidate. And that was on the basis of these certificates.
Yes.
No, or without certificate.
Without certificate, because CLC is necessary.
Without graduation certificate, she cannot be allowed.
No. CLC, once she has college leaving certificate, insofar that private candidates are concerned, college leaving certificate shows that she has passed the examination and the university allows them, because there is no restriction to go through the original.
Anyway, I'm asking, even as a private candidate, if she wants to prosecute, whether these certificates are necessary or not?
No, only college leaving certificate.
College leaving certificate. On the basis of college leaving certificate issued by the
provisional certificate. Yes,
provisionally. What you have issued is a college leaving certificate will be original only. It will not be provisional.
Because that will be kept in the university and to be entered into the registration.
No.
College living
provisional certificate is the basis.
College living certificate is college. Let us be very clear. College living certificate concerning pass of the examination, that will be given to the petitioner. Petitioner, while applying for private examination, PG examination, they have to enclose it. The original certificate.
Now that apart, provisional certificate marks are also seen by the university.
But without that also, you can write the examination as a private candidate.
Yes.
That is no basis.
Yes.
On the basis of college leaving certificate. What have you done now? No, make the sentence. But that counsel appearing for the petition as prosecuted the higher course, namely MA and B.Ed, as a private candidate on the basis of college leaving certificate, and therefore, if can be seated, if at this point of time the records issued by the college are doubted, enormous injustice would be caused to his client. First up. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, this court realizes the competing contentions of equal force, which cannot be completely adjudicated at this point of time on the basis of some original records, other not being available. First off. That being said, no direction can be issued to the university to grant the original educational records for the course in question, including the back paper examinations as rightly contended by its panel counsel. First of all. However, this is not end of the matter. First of all, this court has perused the original records issued by the college as such, on their being produced. First off, no fraud or fabrication is attributable to the petitioner. First off. Therefore, she cannot be sent back empty-handed without granting some molded relief in the peculiar facts of the case. First, next paragraph. On being questioned, learned counsel for the petitioner in all fairness, submits that the records sought for at the hands of the university are required for producing the same to stake claim for promotion to the next higher level in the service of his client. First, learned panel counsel appearing for the college, who is assisted by the present principal, present incumbent of the office of the principal, submits, and this court agrees that the whatever certificates the college has issued years ago can be treated by the departmental promotion committee without insisting upon the production of original records from the side of university. First, that would do substantial justice to the petitioner. First, ordered accordingly, a writ petition is disposed of.
Item 34, item 34 minutes. I filed the content petition. May I pray may be taken up day after tomorrow?
Day after tomorrow.
Also, along with another.
Next week.
Yes, please.
Yes, call next week at the request of the senior advocate. Please.
My primary, I will give that number. Another writ petition is there. My lord's passed an order.
That to be tagged up.
Tagged up. I will give that. I am giving that.
WP number.
WPC number. I am giving that number.
Item 44.
Before my lord, very please, your lordship, matter with respect to
next week, let it come next week.
Well, 2-3 times they have.
Next week at the generally we will not. Our government advocates in my court hall are very efficient. I tell you, I should tell the truth. They are very efficient. They may not be happy on the assumption that I am giving more relief than what is required is another thing. But they are performers. They are performers. They call next week at the request of G. The senior advocate was waiting for one heavy matter.
That's right.
We'll call him. Sir, please come. Sorry, I made you wait in the morning.
Lordship is doing more than what is required.
No, I should not let you wait like this in the morning. I should have told you not to wait actually. No, somehow I also could not. Anyway, I saw you when you sitting here. Yes.
That's learned general is the beauty of the bar.
Yeah, I know. He is to look at Vamana Murti, but as great as Vamana himself. I had heard him in 2 cases. Yes, at the admission stage.
Another senior advocate was here in the name of Vamana Murti.
Okay.
Yes. Yeah. He is no more now.
Okay.
But he was his name was Vamana Murti. C. Vaman
C. Vaman. He was a famous lawyer.
Famous.
And he is also deals with service and constitutional matters. And very good, very proficient. Very proficient.
Some of the
He is
judgments I am
he is
reading.
my senior teacher. When my senior, Ranjit Mahanti, was a kindergarten student.
That
That time,
he was a teacher.
He was teaching in the English school. So that's what my senior revered. And so we are revered to him. He is like our grandparent.
Thank you for your reminiscences.
But here,
yes, sir. Item 47.
the petitioner is a Mahanadi Goldfield Limited.
Do you have any date chart or some short notes, etc.?
In fact, I have not done that.
All. No issue. Start. Are you comfortable?
I have given a list of
Both
dates.
the sides are comfortable? Yes.
I have given a list of dates in my read petition. But I want to give you, your Lordship, just keep everything hands off. Then your Lordship will come to the point. Then with your Lordships, I have already seen the Lordships approached to the brief, and I will put it in that way.
Very well.
If thereafter your Lordship needs any note, any kind, then I will definitely supply.
Well,
here the Mahanadi Coalfield Limited is a central government PSU operating coal mines. It is central government PSU. It is a subsidiary of Coal India Limited. There is a Coal India Limited all over the India, all Coal India Limited one, and it has the subsidiary in very many states. So that they operate only coal mines, and all these coal mines are nationalized coal mines. So and these are also somewhere acquired and vested in the central government. In turn, central government revest with the coal mines. Coal mine companies.
These are government companies.
Government companies.
Erstwhile 617.
617.
Okay.
617. Now that 256, whatever. 242. What we challenge here, a demand under the Orissa Irrigation Act. But for what? We are dewatering the waters in the mine sump. In groundwater, because in mines, the groundwater deposits, it has to be dewatered. So it has to be removed. Because so we removed it. For removal, this becomes an environmental issue. Why? Because MC Mehta in Supreme Court, they have taken it, the Central Groundwater Board, and they have directed this underground water would be part of the Environment Protection Act. So they directed the central government, the Supreme Court directed to the central government that you form Central Groundwater Board as the authority under the EP Act, and that he will regulate the groundwater. And this groundwater, mines water, it becomes a groundwater. There is a regulation. So under the regulation, and we have to take a NOC. We have to apply for that, and we have to take a no objection certificate.
At the hands of the board.
Board
or central government?
No, board. Board because board became the authority. Because the central government empowered the board to be the authority. So that is the Supreme Court direction. Supreme Court, I'll come to that judgment first. Because that was the judgment first of the Supreme Court, under which the Central Groundwater Board became the authority, and he regulates this. And thereafter, I'll come to the guideline of the Central Groundwater Board. And under the Groundwater Central Board, we got NOC. In NOC, we have to dewater. And I'll give also my application where I have to go 165 meter
below in the
ground. So therefore, and what is the Irrigation Act? Irrigation Act is a surface water for river, nala, pond, and everything. This is not
groundwater is not
groundwater is not, and more particularly mines part is not, because in the regulation itself the mines comes. Because whoever owner of mines, he has to take a NOC. Then he will de-water it. And de-water, there is a conditional how it has to be done. And that has to be. So what has happened now? Now, the groundwater has been taken out from the surface water. Because it is an accepted subject became.
After taking it comes to the surface.
Yes.
Then it is sent to where?
Removed.
Removed to where?
Removed because I have to because for the dust removal and everything, I have to do that. Because they have said so. I have to first treat it. Because when it comes from the mines, I have to treat it. Then after treating, then that it has to be done. Because and I generally used for the dust suppression. In the mines, dust suppression, I generally use that. But I have to de-water it according to the NOC. So, Miller, what I intend to say here, now the Supreme Court has stated here that who will be the authority?
Whether under the authority under the State Irrigation Act or the under the
Yes, EP Act. And once EP Act comes, Miller, it becomes a central subject. Then list 12 comes. Once list 12 comes and Article 253, because this is a
distributive legislative power.
Yes, because no 253 is if the union
for giving effect to international.
Because kindly 253 is legislation for giving effect to international agreements.
Is it to give international agreement?
Yes, because environment. All environments are become issue.
So that becomes the central subject.
Yes, EP Act, because in EP Act itself it has stated, kindly see it, Act provide to protection of improvement of environment and matters connected there, whereas the decision was taken in United Nations on the human environment health at the Stockholm.
Yes, understood.
In June 1972.
I have understood.
So
that you are saying so I want to understand.
Yes.
This way.
Yes.
Your argument.
Yes.
Removal of water, groundwater.
Yes.
From the mining pit.
Yes.
That water does not fit into the state subject.
Yes.
Under the irrigation.
Yes.
In as much as.
Yes.
Under Article 253.
Yes.
Whatever law to be made to give effect to international conventions, treaties, etc.
Yes.
Will be exclusive competence of the parliament.
No, here Miller just add it. This became part of EP Act.
EP Act is a state or the central legislation only.
Central government. And Miller, a regulation has been created under the EP Act.
No, two things are there.
Yes.
Whether environmental protection is an item in the list.
Yes.
List one.
Yes.
Kindly say, show sense. You get the constitution. Take out the Schedule 7, list.
Yes. Miller, that is 12 and 13 it will come.
12 and 13.
Because United Nations organization and participation of international conference, association and other bodies implementing the decisions. This will come this way.
Whether environmental.
No, environmentally there is no subject. Environment created, that is what was in the preamble.
No, preamble you have read it.
Yes.
But whether what is stated in the preamble is a gospel truth?
No, that's not. But that indicates.
It's indicative, presumptive also.
Yes.
Presumptive also.
Presumptive, yes. It indicates presumptive. And more so,
law relating to environment is not a subject.
No, environment is not, that is no subject.
Just see. Note Schedule 7 the environment.
Because 92 lists are there, it is not. Water is a subject under the list 2.
Water alone is the subject.
Yes.
Whether this is within that or not is also the question.
List 3 also it is not there. So therefore,
no, list 2 if it is there.
Yes.
Then state will have
to follow.
But your argument is,
yes,
since this law is made to give effect to the international convention to which India is party,
yes,
it fits into 253.
Yes.
Regardless of whether it is stated in list 1, list 2, etc.
Yes.
That will be the central legislation.
Central legislation.
Therefore, board alone has got jurisdiction.
Yeah, jurisdiction.
No levy can be made by
the regulation made by central, it becomes a law under the Article 13.
13.
13.
13 is how that will come to your aid. 13 applies to.
No. Why I am saying it is a law.
Not available to you.
No, it is a law. Once it is a law, then it comes to 246(1).
No. 13(1) is confined to Part 3.
Miller?
13(1) is confined to Part 3 of the Constitution.
No, 13(3).
It is confined to Part 3.
13(3). Law includes any ordinance, order, bylaw, rule, regulation, notification, custom and usage having in the territory of India the force of law.
That is for the purpose of 13(1) and 2.
Yes.
Not for that article. There are judgments.
Yes. So that is what I said. That way.
Not correct.
Yeah.
There are judgments. V. N. Shukla on constitutional law has enlisted such judgment.
Yes.
Therefore, that argument will not help.
Okay.
Any other argument do you have?
Yes, Miller. So this is the first argument with regard to that. This is the not subject within the state list. Then kindly see the regulation itself. No, first kindly see MC Mehta. MC Mehta is 1997-11 Supreme Court 312.
Can I just articulate my points?
Yes.
Based upon your submission.
Yes.
Learned senior advocate appearing for the petitioner submits that no levy could have been made under the Orissa Irrigation Act 1959.
Read with
in
Odisha Irrigation Rules
1960. Read with rules promulgated thereunder
1961.
In 1961. In as much as the groundwater does not come within the framework of the state statute legislation. Number one. Number two. Assuming that water figures as an item in the list 2 of 7th schedule, still it is only the parliament which can enact law to give effect to the international conventions, treaties, conferences, etc. in terms of Article 253 of the Constitution. First off. 3. In the light of MC Mehta versus so and so citation you give, because there are many MC Mehtas.
1997-11 Supreme Court cases 312.
312. Read with the Environmental Protection Act 1986. The state has absolutely no competence nor jurisdiction to make the impugned levy. Next paragraph. Clause 3 of Article 13 of the Constitution expansively defines that word law. And therefore,
Regulation is a law.
Regulation made
by central,
promulgated by the central government under the EP Act.
Yes.
In the light of MC Mehta.
Yes.
Is a law. And therefore?
Therefore, the state ousts its jurisdiction for the central underground water.
And therefore, there is no scope for the operation of state law.
Yes.
These are the 3 points.
Yes. These are points. Then I'll come to the what is demand. That part you will achieve latter part declare.
Understood.
Now you will achieve kindly come to
do you want to modify these articulation?
No. It is absolutely correct.
Do you want to modify these articulation?
In my submission, I'll say.
So Miller, kindly see 1997 11 Supreme Court, page 31.
Before that, can we see the EP Act?
Yes.
Because it is anterior to this decision.
Yes.
Yeah.
No, why I am showing this? Thereafter I'll show the groundwater regulation, then EP Act. That is my scheme. Yes.
Give that copy of, yes. This is the, whether water is defined anywhere or it's a common parlance definition.
It is, I'll give from the definition, because what is the groundwater and what is the subsoil? I'll come, Miller, one by one I'll come, then your Lordship will see. Your Lordship kindly take the page 317. 312 at page 317. 317, para 7.
Yes, sir.
My Lord has got?
Yes, sir.
Para 7. Then fourth line. I will start with fourth line.
It is no doubt that.
It is no doubt correct that there are legislation in some state to regulate water resources development. But by and large, the underground water is being exploited all over the country without any regulation. It has therefore rightly suggested by NERI in its report that an authority under the Act be constituted with powers necessary to deal with the situation created by depletion of groundwater level, dwindling surface water surfaces, and deterioration of surface and groundwater quality and haphazard land use. Then para 8, we therefore order and direct as under para 9. The central government in the Ministry of Environment and Forest shall constitute Central Groundwater Board as an authority under section 3, bracket 3 of the Act. The authority so constituted shall exercise all powers under the Act necessary for purpose of regulation and control of groundwater management and development. The central government shall confer authority the power to give directions under section 5 of the Act, and also power to make such measure or pass any order in respect of all matters referred to subsection 2 of section 3 of the Act. This is what this has been declared.
Let us see subsection 2 of section 3. Let us see. I don't have much exposure to this Act.
Yes.
Let us see the frame of the Act. Let us see how. Environment Protection Act 1986. This Act itself is made to give effect to the international convention.
Yes.
Any decision says like that? MC Mehta अथवा PUCL अथवा
I will give Miller. I have not brought today.
I feel.
Yes.
I vaguely remember.
Yes, I have, but I have not.
Research much. ಯಾವುದಾದ್ರೂ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಈ ಎನ್ವಿರಾನ್ಮೆಂಟ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ ಅನ್ನ ಟು ಇಫೆಕ್ಟ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಕನ್ವೆನ್ಷನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದೀರಿ ಅನ್ನೋ ನೋಡ್ಕ. ಎಸ್, ಬಟ್ ಒನ್ ಥಿಂಗ್, there are judgments, American Supreme Court judgments, our judgments also, which say what the preambular part of the statute will say is not conclusive.
No, Miller.
Court is entitled to examine that.
Yes. Miller, your Lordship has see 3.3, paragraph, subparagraph 3.
Now, let us see the preamble. An act to amend certain enactments for discriminating as rationalizing offenses for no, this is not.
No, preamble an act to provide protection and improvement of environment.
Protection and improvement of
protection
and for matters connected
therewith. And whereas decisions.
Stockholm Jones, even conference human environment held in which India participated for protection. Whether India is a signatory to this Stockholm Agreement?
Miller, otherwise they could not have brought out this. That's that we have to infer that way now. Yes.
Yeah. Right.
And whereas it is considered necessary further to implement the decisions aforesaid in so far as they relate to protection and improvement of environment and prevention of hazards to human beings and other living creatures, plants and properties, be it enacted by Parliament, the 37th year, the Republic of India, so and so.
Come to 2A.
Then 2A.
Yes.
Miller, A is under this Act.
Unless the context otherwise. Definition. 2A.
Yes.
2 is a dictionary clause of
environment, yes, includes water, air and land. And interrelationship which...
No, before that there is one more sentence.
Yes.
Unless the context otherwise requires.
Yes. Yes, that is correct. Context otherwise requires.
This water, air and land. And the interrelation exists among and between water, air and land. And human beings and other living creatures, plant,
Miller, please see the judgment 314, para 314.
Page 314.
Page 314.
Of MC Mehta?
Yes. There one line I will show to your lordship. Miller, your para 4, your lordship kindly come.
Yes.
Then this court on 5/12/1996 passed the following order.
5/12?
In the middle of the page.
You are right. This court on 5/12/1996 passed the following order.
Then kindly come to Miller after 1, 2, 3, 4, 5, 6.
We do not.
6, 7th line. We are
prima facie of the view.
Prima facie of the view that act being an act made by Parliament.
You are right.
Under entry 13, list 1, read with Article 253 of the Constitution, it has an overriding effect.
You have answered it now.
Yes. It is not necessary to go anywhere, my lord.
In support of his submission, counsel draws attention of the court to the observation of Apex Court in paragraph 4, page 314 of MC Mehta Supra, wherein it is specifically stated that the EP Act has been enacted under entry 13 list 1, read with Article 253 of the Constitution of India, and therefore it has an overriding effect. Overriding effect on whom?
Miller, on all other, because it only come to Miller 246(1).
246(1) is exclusive power of the Parliament to make law.
Law.
Correct.
So, and that is with regard to the subjects.
In the list 1.
And Miller, now they have made the law under 246(3). So therefore 246(1) has an overriding effect. Because kindly see 246(1).
246(1) is center. 246(3) is state. So overriding has to be in respect of law made by the center, not the state.
Yes. And this is a law because this is a regulation under the EP Act.
No, law includes the law is not defined in the Constitution.
No.
It is not defined, but existing law is defined.
Yes. So your lordship can see 246(1), notwithstanding anything.
That's right.
Notwithstanding anything.
No, I got it. I have understood it. You can go further.
Yes.
Yeah.
So now, my lord, after this, my lord, your lordship kindly come to 3.3 subparagraph 3, because the Mehta has said 3 subparagraph 3 and section 5. 3 kindly see. The central government may, if considers necessary or expedient so to do, for the purpose of this act, by order published in official gazette, constitute an authority or authorities by such name or names as may be specified in the order for the purpose of exercising and performing such of the powers and functions, including powers to issue directions under section 5 of the central government under this act, and for taking measures with respect to such matters in subject referred to subsection 2 as may be mentioned in the order, and subject supervision control of the central government and provision such order and authorities may exercise the power, perform the functions and take necessary measures so mentioned in the order, as if such authority or authorities had been empowered in this act to exercise those power or perform this function to take such matters. So, Miller, 3 has been now Supreme Court directed. Central Groundwater Board would be under an authority under 3 and 3.
2, 3.
3.
3.
Yes.
But Supreme Court used the section 2, 3. You read it just 2 minutes ago.
2, 3. He will do the work. 3, 2. Do the work and authority under 3, 3.
Authority under the 3.
3. Be kindly similar. The word is shall constitute Central Groundwater Board as an authority under section 3.3. So this is an authority under 3.3.
To board is an authority under section 3.
3.3, and he will do the work under 3.2 and also power to give direction under section 5. 5 is notwithstanding anything contained in any law, other law, but subject to provision of this act. Here again, notwithstanding anything, other law contained in any other law, but subject to provision of this act, central government may, in exercise of its power and performance of functions under this act, issue directions in writing to such person, officer or authority, and such person, officer or authority shall bound to comply such directions.
That expression other law,
yes,
is not to the state act at all.
No, law as a whole.
No, law that can be made by the parliament.
Maybe your lordship may restrict it. Your lordship
is same.
Yes, your lordship may, but that will not make difference.
Correct.
Because otherwise, whether state law will prevail or the central law will prevail. Here the central law
we will go to 253, 254.
Yes.
Whether Irrigation Act is made under 254 consent.
No.
That even otherwise that may not be, because 253 excludes power of the state legislature.
Yes. And Millard kindly come thereafter to the regulation, Millard, framed by the Central Groundwater Board. Millard, I have
counsel refers to section 3.3 and section 5 of the GP Act. First section, he stresses the term notwithstanding any other law. Any other law or any law? You can sit and argue if you want.
Yes.
You can sit and argue also.
No. Millard, I have to maintain the decorum.
No.
As long as I am able to come here, I will maintain the decorum and I will respect, because other they will not
be seeing you.
Because
grateful to
I should not have a departure.
I appreciate that.
Yes,
I appreciate.
Well, I am trying.
If any Ayodhya judgment, in Ayodhya case,
yes,
our Parasaran,
he was allowed to sit.
Argued the matter,
yes,
without sitting, without wearing the chappal.
No, shoes. Millard, what has happened? Court directed him that you please sit and argue, and we will provide the mic. He refused both.
You are also like that?
Yes, without Millard, I have the opportunity of working under him. because he in 2-3 matters of Mahanadi Coalfield, a big matter, taxation matters which amount to 600 crores and above, he came over this High Court to argue. And so I had my opportunity to assist him. And I have seen him, because that is what I don't wear this robe. Okay, this, because Parasaran never wore. Because those are the things I have learned from him. He and Santi Bhushan I have seen in the Supreme Court, they don't have this coat like this. They have plain coats. So that's what I have seen, that these are the people who are so learned. Because we can touch even 1% of their knowledge, yet they are so humble. That's the so they mingle with everybody.
You are also like that only.
No. It's a great thing to mix with them. They always, even they call us sir. They suppose, because after say 2 years he will meet me in the Supreme Court. He forgets my name naturally, but he will say, sir, how are you? Then I'll say, sir, I'm Sanjit. Then he will call me Sanjit like this.
In fact, when he used to call Indira Gandhi as Hindu.
Yes.
The Prime Minister used to be addressed as Hindu.
Yes.
And in Indian Express matter, he sent a letter. I am not in a position to defend this until you engage some other advocate. Then Srimati Indira Gandhi, she used to respect him like anything. And said, no, you only have to argue this matter. Whatever you want to say to the court, you tell it, don't worry about it. That was, and Palkiwala, after seeing his fairness, fearlessness, gives a letter in the open court to Mr. Parasharan, saying that I am yet to see a person of your stature.
Yes.
This is how these people, the bar is developed that way.
No, that's what he always, and he always, Milord's another part is beauty party. He has once stated, when in one of this Supreme Court, all India, the Judges Association case, these judges cases, he said there is no difference between the first row of the bench and the other side. What the difference? It is the providence. You have been ordained by the Lord to sit there and to dispense justice. And
I don't consider it as a boon at all. I came to know it after elevation.
Yes.
So I would have been very happy at the bar.
No. He said, because he said with regard to knowledge, he said there is no difference. But what is the difference? It is you are ordained. You are ordained by the providence to sit there and to dispense justice. Therefore, you are there. So once that has been done, Milord, that what you are doing, that's the correct approach to the bar, because you are trying to dispense justice as much as possible. That's the best part. Milord.
That's how we are. Both these are like that only.
Yes.
To do justice.
Yes.
We can quote jurisprudential theories and send the litigants back.
Yes.
Every case we can dismiss.
Yes.
But our oath will be violated.
Yes.
We are there to do justice to the parties. But I am enjoying your arguments. The jurisprudential level of your submissions are very high. And I can catch it.
Milord,
with humility, I say.
I'm obliged, Milord.
Yes.
Milord, your lordship.
So 3.3 you have read?
Yes, 3.5.
Then 2A you have read.
Yes.
You have read section 5 now.
5. Now, Milord, I am coming to Central Groundwater Authority regulation. That is, I have given at Annexure 9 of the rejoinder.
Also give attention of the court to para 7, 8, and 9 of MC Mehta. Do you want me to advert to MC Mehta again?
No.
Take this. Keep it. Yes.
Milord, your lordship, Annexure 9, page 23.
Yes, sir.
Of my rejoinder. Page 23, your lordship got.
Guidelines to regulate. There are so many whereas.
No,
Anyway,
I am reading first whereas.
First whereas.
First whereas. Whereas on direction of Honorable Supreme Court, vide its order dated 10th December 1996.
The same judgment.
The same judgment.
Why notification dated ground water authority so and so?
Yes. Exercise power under Section 5 of the Environment Protection Act for purpose of regulation and control of groundwater management. This is what groundwater has been taken out. Groundwater management and development, and to exercise certain powers and performs and certain functions relating. Miller. Then your lordship kindly come to Miller, then whereas page 24
to this page. Page 23 and extra 9. And mark, yellow mark that first paragraph, first whereas paragraph. Yes.
Then your lordship come to page 24, last paragraph of that whereas. Now therefore, in pursuance of the direction of Honorable National Grid Tribunal and powers conferred by subsection 3 and section 3, read with section 5 of Environment Protection Act, the Department of Water Resources and River Development hereby notifies the guidelines
to regulate
groundwater extraction. In the country. Yes, in the country. In supersession to this ministry notification dated as per the this country, total country. Then your lordship kindly see 25, page 25.
That last paragraph also, page 24. Now therefore.
And Miller.
Make that.
Yes.
Put that. Yes.
You kindly see the first paragraph is the repetition of the first whereas.
Page 24. Right?
Page 25. Your lordship turn to page 25.
You are right.
Then first paragraph preamble and background. Thus it is same as that of MC Mehta. Then kindly come to second sub-paragraph. The authority has been regulating groundwater development and management by way of issuing no option certificate
for groundwater
extraction
to industries,
no infrastructure project and mining
projects. Okay.
So mining project is a specific.
Yellow mining project. See, page 25. You have highlighted preamble and background. Go to the second paragraph. There you will see mining projects. Third line, second line, last word, mining project. Got the point? No. Mining project. There only. Make it yellow.
And Millards, Miller, I continue thereafter.
Yeah.
And framed guidelines in this connection from time to time applicable in 22 states and 2 union territories where groundwater development is not being regulated by state government and union territory administration concerned.
If groundwater is regulated?
Not. Kindly come to here. Miller, kindly come to
page being regulated by the state government and union administration concerned.
Page 57 of the same Miller, kindly come to page 57. 57. Huh? 57. No, sorry. Come to.
Not applicable in Odisha.
Not applicable. Page 48.
Because Odisha being regulated by Act and rules.
Page 48. There they have stated 22 states. You also has read 22 states not regulated. Kindly see list and
that this is dated what?
You are dated 24th November, 24th September 2020.
This is what document actually?
This is the regulation I have given.
Made by the central government.
Central.
Board. But board has ignored arguably. Arguably. Board has not seen the Orissa.
Miller, they have given a declaration means Miller with regard to groundwater. That is what your lordship can see guideline to regulate and control groundwater extraction in India. This is groundwater extraction in India. So your lordship kindly see that, and here Miller kindly see 48, page 48, annexure 8 Miller. Page 48, kindly see page 48.
Yes.
Miller, the annexure 8, your lordship can see after the signature of the judges. List of states and union territories where groundwater extraction is being regulated by central government groundwater authority. And that is Odisha 16. One 6.
Page?
Page 48. You can turn to page 48.
Go to 40. Ah. 16.
16 is Odisha.
You are right.
So here 22 states they have stated where there is no groundwater extraction legislation. And here they have said that Odisha doesn't have, because they have included Odisha specifically. Therefore, the Orissa Irrigation Act doesn't have the groundwater extraction.
Only surface water.
Yes. What I intend to say, my lord, groundwater is different from the surface water. You have a government water resources. I will show that. What is that definition? That doesn't include the groundwater extraction. And here, Miller, what is I am pumping out. Because I am pumping out the water from the underground.
Industrial purpose.
Yes. And that is what. And now you can treat it as a surface water. What they are saying, they are treating it as a surface water and asking me to pay. And in fact, I have paid till the last 2 months. I have paid till last 2 months. Then I have come here. So what is I am showing, my lord, because this central groundwater, the groundwater, underground water extraction doesn't cover the act made by the state government.
That is the only question.
That is the only question. And thereafter, even your lordship will see whether the demand is correct or not. I will come to that. That is
assuming that they have jurisdiction.
They have the jurisdiction.
The demand is also defective.
Defective. I will show that. That I will show to your lordship. From the pleadings and that I will show to your lordship.
Yes.
Yes. So now, Miller, my first submission with regard to this regulation is there is no.
I'm off. Big pardon.
No problem. Okay. Yes.
Then your lordship can see page 28.
Council submits, drawing attention to the regulations made by the board by notification dated 24/9/2020 at Annexure 9 to his counter, to petitioner's counter, that the state of Orissa figures at serial number 16 at the page.
Annexure 8, page 48. That is your lordship can see Annexure 8 at right hand side.
At Annexure 8, page 48. Running page 48. As one of the 24 states wherein groundwater exploitation is not done.
Groundwater extraction.
Extraction is not done.
being regulated.
And being regulated. First term.
And mining projects are covered.
That I have already covered.
Yes. Milord, and this notification, Milord, these guidelines will come into force immediately on the gazette notification.
And they are gazetted also.
This is gazetted.
These regulations have come into force on being gazetted. And therefore, the levy under the State Act is incompetent.
Yes. But this I have given the Gazette of India. This copy.
Yes.
I have copy.
Yes.
Which I have given Gazette of India copy.
Yes.
I have given.
Yes. Gazetted on?
That the same date, 24 September 2020.
Yes.
Now, Milord, after this, Milord, kindly see page 28, mining project. Page 28.
28 of?
The same regulation.
Same regulation.
Same document.
This is put on. Application. Page 28.
Yes. 4.2, Milord, last, your lordship come to the last part.
4.2.
Yes.
Mining projects.
Mining project.
All
existing as well new mining project will be required to obtain no objection certificate for groundwater abstraction. This is what, Milord, I am coming. And since mining projects are location specific, there will be no ban on grant of no objection certificate for abstraction of groundwater such project in overexploited assessment units. No objection certificate for mining project shall be granted subject to following specific conditions. And it shall be mandatory for all mining industries to ensure water available from dewatering operations is properly treated and should be gainfully utilized for supply for irrigation, dust suppression, mining process, recharge in downstream, and for maintaining e-flows in the river system.
4.2 point Roman small one. Yes.
Now, Milord, please come to my application for no objection certificate and no objection certificate. These two documents I will show. Milord, Annexure 6, page 50 of writ petition.
Five zero.
There you will also kindly come to serial number 5 at the bottom.
Page 56 or 50?
50.
50.
Milord, this is the application, and I am the Jagannath Kollieri. Milord, their name of the mine and project at serial number 2, Jagannath Kollieri. Then your lordship kindly 5. Details of existing NOC issued by CGWA. NOC, Milord, first NOC date of issuance is 31/1/20. I have taken from 31/1/20 because this is
validity is 31/2022.
2022. Now, Milord, that has been renewed till 26. I will show that.
Renewed that.
Yes, that I will show.
Council submits that. The no objection certificate are in operation from 31/1/2020 to
Milord, kindly see page 61.
31/1/2026.
Kindly see page 61.
I go by your version.
No, that is the document I have given.
Page 62.
These are at annexures.
Annexure 7, page 61. serial number 8, 7 valid from 31/1/2024,
7, 6 and 7.
valid up to 31/1/26.
Yes.
And kindly see 11 groundwater abstraction restoration charge is 1,23 lakhs I am paying.
At serial
Yes,
number
11.
11. In the no objection certificate at Annexure 7, the amount paid as a groundwater abstraction price charges is mentioned. Yes.
1,23 lakhs.
In a sum of rupees.
1,23 lakhs.
1,23,109,49.00.
And Millard, page 52, you will also kindly see.
That is for what period you have paid this money?
For these 2 years?
For 2 years.
Yes.
31/1/24 to 31/1/26.
31/1/24. Between 31/1/2024 and 30 January 2026.
Right.
For this 2 years. Millard, your lordship can see page 52. This is my application where your lordship can see I go up to 165 meter. 11B. At what depth? 11A is at what depth? And B
But
is...
this is application.
Yes, because this shows me not...
Where is the certificate? NOC?
NOC is this?
No, in NOC.
Yes.
Where have they stated?
No, they don't mention.
Only
They grant
application.
They application, on the basis of that application, they grant this NOC.
NOC does not mention all these things?
No. NOC, Millard, what NOC mention, I will show Millard. NOC, what NOC has mentioned, I will come to that, Millard. But kindly see application, page 52. I want to show that underground means 165 meter. It is not that subsoil. Because there is a word subsoil they have used in the State Act. Subsoil means beneath the surface.
Beneath the surface.
Yes.
It does not go to the center of the earth.
Yes. Here it is, kindly see, my maximum depth, I will go to D water, page 52, kindly my lord, page 52, 165 meters.
The no objection certificates, when read along with the application, therefore, shows that the industrial activity can go beneath the surface up to 165 meters.
Yes.
165 meters.
Mining area, mining.
That's
open cast mining.
Yes.
For the purpose of mining.
Once it is removed.
And the council submits that this depth would not mean subsoil.
Yes.
Which term is employed in the State Act? Yes.
Here you kindly see what they have used, MBGL in B.
Means?
MBGL, that means meters below ground level.
It draws attention to the abbreviation MBGL. Meaning meters below
ground level. That is how it is a groundwater. It's a groundwater.
Therefore, it is a groundwater.
Groundwater.
Sense.
And it is for dewatering. Dewatering of the mining.
And yes, in the mining activity, dewatering is an integral component.
Yes. Integral compact, Millard. This is what I have done, Millard. This is what I will. But kindly see page 7. Annexure 7. Page, Millard, this is the no objection certificate which your lordship has seen. Then turn to page 62.
Yes, sir.
Page 19, in case of violation of any NOC condition, applicant shall be liable to pay penalties as per section 16 of the guidelines. So it's very strict. No, then 28 can see. In case of coal and other base metal mining project, the project proponent shall use advanced dewatering technology.
No, what for you are showing it?
Because dewatering is, I am showing.
No, that's the technology as to how you are going to do.
Yes.
So question is, our focal point is,
yes,
is it groundwater or not?
No.
Or it is the waters in the subsoil?
No, that is one. Second, Millard, dewatering. One should know that what is dewatering and not. Because dewatering means I have to extract
the water. You have to remove the water.
Yes.
From that place.
Yes. So that can be a surface water. Because there the demand shows that it is surface water.
It's in the counter of it.
In the state act.
Yes. The demand there is a
council submits that. The idea of dewatering involves removal of water from the deep ground level as part of mining activity. And therefore, what you say?
Dewatering is not surface water.
And therefore, that would not fit into the idea of surface water contemplated under the State Act.
State Act, and you see State Act, Orissa Irrigation Act, 46A, 46 small a.
Yes. Let us see at the preamble.
Yes. Millard, an act to consolidate and amend laws relating to irrigation, assessment, and levy of water, rate and cess in force in different parts of state of Orissa, and to provide for regulation of use of water from government water source, use of water. Whereas it is expedient to consolidate and amend laws relating to irrigation, assessment, levy of water rate, and cess in force in different parts of state of Orissa, and to provide for regulation for use of water from government water source. So, Millard,
this is relatable to entry?
Millard, 17. 17.
Let us see the entry, how it reads.
It is only water.
Water.
Yes.
Next. Council submits that Orissa Irrigation Act 1959, as its preamble indicates, regulates use of water from government source, and the act is relatable to entry 17 of list 2 of 7 schedules.
Yes.
That is
how it reads.
Water. That is to say, water supply, irrigation and canals, drainage and embankments, water storage and water power subject to the provisions of the entry fix of the list 1.
Entry 56 is inter-rivers.
Subject to means in respect of the center will have power.
Yes.
So including that, this
yes, water, that is to say, water supply, irrigation and canals.
Irrigation, canal, drainage, and embankment.
Say entry, please. It does not include groundwater at all.
The water supply.
Water supplies. Where is the supply?
Well, here it is mentioned water supply.
Correct. Where how? I'm just asking you. Yes. I do not know. I meant to hear you. Just off the cup, I am asking you.
Yes.
Where is the idea of the groundwater.
Yes.
Ground level water,
Yes.
deep ground level water,
Yes.
fitting into the
Mining
entry in 17.
Yes.
Entry 17 is, although the entries, the Supreme Court said these entries are to be liberally construed. They are fields of legislation, not powers of legislation. Anyway, even then, under this entry, where do you fit?
That is water supply?
Water supply
Because your lordship, my learned senior was showing your lordship that the government, that this amendment came in 1984. 46A. Act.
Anyway, I'll come to that after senior completes.
Yes.
Yes, sir. You mean to say,
Yes.
a fit and substance of your argument is read with 346(1) and 353. 253. In the light of MC Mehta and the regulations made by the board, the state has no role to play.
Because specifically MC Mehta said the groundwater has to be taken out. Because the MC Mehta, because it's now a Supreme Court law. So there is no Miller below the groundwater. Groundwater doesn't mean surface water. There, Miller, what they are trying to say that there is a supply of water.
Where is supply?
So because I'm taking out the water.
That is dewatering.
Dewatering, but they are saying it is supply.
Supply has its own meaning.
Yes.
The Supreme Court has interpreted the word supply. Call Surendra Malik words and phrases.
I am putting so much labor, your lordship.
No. I'm very happy. I'm enjoying your argument. In fact, there is a series of 21 volumes, English words and phrases.
Yes.
Legal words and phrases. I do not know whether our library has got, the judges library has got. Just look into what is meant by supply. Let us see the word, meaning of the word supply. Whether that is it defined under the act? Supply of water is defined under your act?
No. Supply
is not. Water supply is not defined.
No. Water supply,
No, even otherwise, they cannot define certain thing to by way of over-inclusiveness.
Yes. In the counter also they are not saying water supply. We are inferring. We are inferring they are trying to say that. Yes. Your lordship.
I had an opportunity of treating a case under this act.
Yes.
I treated one particular case under this act, which senior Mr. S.K. Paddy had argued.
Yes. I got that.
Do you have got that?
Yes.
Any other points, sir?
Yes, Miller, I want to show in that Odisha Irrigation Act, they are relying upon this provision. 46A.
46A.
46 small a. Government water source.
Means
any water source created naturally or otherwise by collection, deposit of water at a fixed place. Fixed place.
Any subsoil
water. Here, Miller, that is what I say, subsoil. Subsoil water or water in a state of running, such as river,
nala, streams and the lakes,
and like, which is other than irrigation work, is the property of the government. So they are saying this is a government water source from where it is supply is being made. Therefore, you are liable to pay. Whereas our case, we are covered under the NOC. NOC is granted only for the mining project and that too dewatering purposes. And dewatering purpose is different from this. There is no supply. This is not it is a removal of water and a removal for a specific purpose. They said that you have to use it for dusting, for doing this.
After removing this water,
yes, you are
treating it.
Yes.
Where do you put it?
That is what 28. Kindly see 28. The NOC 28.
What it says?
It says that in case of coal and other metal mining project, the project proponent shall use the advanced dewatering abstraction to avoid
technology aspect.
No. To avoid contamination. To avoid contamination, I would use that. No. See, dust operation.
Suppose use water, you dewater.
1 minute, I have lost. 1 minute. Yes. Yes. Milord, in the regulation 4.2.I, page 28, it shall be mandatory for all mining industries to ensure water available from dewatering operations is properly treated and should be gainfully utilized for supply of irrigation, dust suppression, mining process, recharge in downstream, and for maintaining e-flows in the river.
Council draws attention of the court to
4.2.I
regulation
of regulation
4.2.2
then I at page 28
shall be mandatory for 4.2.I.
Yes.
To answer the question as to what they will do with the water, with the dewatering yield. It's dewatering yield. Yes.
So therefore, Milord, their 4.6.16A they are using.
Their amendment.
Yes. Their amendment
will not cover this.
This not cover.
He submits that the amended section 4.
4 bracket 6
small a
bracket 6 small a
would not apply to and cannot be applied to case of the petition.
That is government water source.
That's what.
And we have mentioned in our read petition at para 8.2, during extraction coal mines from the mining operation, water sources were created. The said water sources were extracted for safety of mining process and utilized to suppress dust in the mining.
He also draws attention of the court to paragraph
8.2 at page 8.
8.2 of running page 8 of his petition as to what they do with the yield of dewatering.
Yes. Now
we are consistent with the regulation, the subject regulation.
64.
Sir, can you hear further some other day?
In fact, I have my difficulties.
No, whichever day you find.
Can it be in January?
Yes.
Then January, any date your lordship give.
Very well. In the meanwhile, I have a request to make.
Yes.
Prepare the outlines of your argument.
Yes.
Which you have already submitted.
Yes.
I will also read and come back.
Yes.
Very interesting point is involved.
Yes.
Many aspects are involved.
Can I have a rough copy of your lordship dictation?
They are haphazard. I can share. They are haphazard. They are not that organized. But I can share that.
Yes, please.
Share copy. I just prepare them.
No.
Then I share.
Your lordship kindly, because your lordship has really labored very hard.
No.
No.
Very playfully, I have heard you.
No.
Very playfully, I have processed the matter.
No. So that I will just develop that.
Very.
I'll just develop that and to put it and to put it neatly so that I can do.
Very good.
Yes.
That is.
One minute to go. We are always
Heard learned senior advocate appearing for the counsel on record for the petitioner. First off, for paucity of time and also because of the complexity involved, the preparatory work has to be done by the court by studying the latest legal position canvassed before the court, before it, this day, passionately canvassed before it, this day. First off, call this matter on which day, whichever day you can put down that January 2nd week. January 2nd week, all right, sir?
19 to 20. 1920.
1920.
19 is a Monday.
Monday. On 19 January 2026 for further hearing.
Interim orders to continue.
Interim order to continue.
There are two matters.
Both the matters.
both have been tagged.
Yes. Interim orders. Let's see, appearing for the question.
You actually
appearing for the OPs.
You actually make it Pata.
Yeah.
Pata.
For further hearing.
For further hearing.
Yes. Since matter is partly heard.
What he is saying, if your lordship will make it a part heard so that it will come before this bench.
If it goes before other bench also, I'm extremely happy.
No. Because the effort made by my lawyer senior.
Yes,
it will go.
Rather he is helping me. It is not he helping himself. He is helping me.
Not in case.
Yes.
Not in particular case.
No. Helping me in the
in the sense.
It's a fairness. It's a fairness. It is a fairness that
I will also make updation.
Yes.
I will have some time during the vacation also.
Yes.
I'll just go through with my notes.
Yes.
I have some notes on this aspect.
Yes.
Which I did during my lawyering days.
Yes.
I just refreshed them also.
I've passed that judgment, your lordship has delivered in.
Share that copy with senior.
I'm having only one.
Yes, Xerox and give it.
Give it, I'll share.
Your supply. Awesome. Okay. Just go through. These aspects are not covered. It's in a different context.
No, I will.
Mr. Padi argued that matter so passionately.
Yes.
He left no option to me than to pass an order in his favor.
But your lordship has discussed about section 6A.
6A also discussed.
That may learn senior was.
Not in this context.
Not in this context.
In the context of distributive scheme of legislative powers. In that context, I have not discussed. That was for some other different.
No, I'll read it. Once
that may throw some light there. May not be much relevant.
Yes.
But we will have another angle also.
Interim order to continue.
Interim orders to continue.
Both detectives.
Yeah.
Well, I'm obliged.
Thank you, sir. Thank you so much for enlightening the court. Yes. Can I leave the court now?
Only, my lord, item.
Your matter.
I not give the letter.
You want that
kindly
matter
fix
to
a
be-
date. That's it, because I have some copy, so that it can be.
45. Three times.
Which date you want?
14th next week, any date, lord.
I'm sorry, my lord. That item 48.
9th of.
My lord, I'm sorry, my lord.
Ninth
Till 15th, I will be.
No, he wants.
In that case,
You
I
are
am
there. You are there.
But till 15th, I have he knows why. What is my problem? He knows, my lord. Till 15th, any day after 15th, my lord. Any
Can
day
we have it on
item
16th?
48.
1/6.
I have a small prayer.
In that case,
This only.
yes, in that case.
Okay. You have too many problems now.
I have filed an application to be added as a party to this case
because I am the successful candidate of the post which was challenged.
I don't agree on that.
I don't have any objection. Lordship will ask. He can assist Lordship. I don't have any objection.
I will be so that I can proceed.
I don't have any objection,
In
Lordship.
that matter,
Lordship.
Then I will be allowed.
application supported by an affidavit in IA number so and so is moved by the selected candidate who answers the description of proper party, if not necessary party, in the light of Rajia Begum. First off, learned counsel for the petitioner in his usual fairness, very fairly fairness submits that the application be allowed and the applicant be permitted to be arrayed as OP number so and so. 6. Accordingly, application is allowed and the petitioner is directed to array the applicant as OP number so and so. So and so. Only it is open to the newly added. Sir, you need not wait. I have some. Need not wait.
It's my duty. My Lord, 6, my Lord. Only let's hear 3. Let's.
IA, the newly added part OP can file his counter to the petition. First, call this matter on 16-1. 16-1 or
My Lord, 6 item, my Lord.
Wait. Next week.
16 December, Lord. 16 December.
16 December.
December.
That's what. 16 December.
Yes.
Yes.
Lordship, only pay let you one.
Other matters.
Lordship,
Give everybody date.
Lordship, interim to continue.
Interim order. There is interim order.
Lordship.
Then why January? We will have it in January.
No, Lordship, it's not. Have the interim order, my Lord. Suffering, Lordship. Despite interim order, they are continuing where I am not allowed. Despite interim order, I am not there, Lordship.
16, 12.
Lordship, 51.
Take one date now, today, not possible. This new year you take. Come twice.
3 times.
All right, you come 2 more times. What to do? There are cases, we don't play cards here. We do work. Choose some date in January. December, very difficult. Otherwise, I would have given you. Again, you will say 4 times I have.
Last 30 years on judicial.
Therefore, choose a date now.
Date to come.
Give some, take some date in January.
January, item 48. My appearance letter. Section number 3. 6 January.
So it's 6-1, reopening day. We'll have it in the second week.
Second week date to go.
Second week of January. Give date, party has to come. Second week. Rest of the cases all in January.
Well, item 51, there is urgency, I place second week of December, 8, 9 or 10.
In the first week of December.
My lord.
Yes. Okay.